Kia ino I tātou. Kia tata tonu mai koe kia mātua I hoa I roto I tēnei noho mo te roa ngā ki o tēnei roa. Kaupare atu koe ngā wairua kino ngā wairua poke kia kore ke uru mai ki roto I tēnei noho mātua te rānei. Engari ko tēnā ki a koe ke manaki tēnā koe ngā kai kōroro. Ke mua rātou haka ātūranga ki mua I te auraro te tēpū. Me te manaki o ke te tēpū ki te tātaringa kupu. Me te rapu I te huarahi kia puta kene pai ngana mo te marea. E whai pā ngana ki tēnei kaupapa. Ko te ina ki tēnei ki a koe pā maune whakamana mai. I runga nei te ngua tāutama te kai whakora ko I Kraiti. Amen.
Morena tātou, welcome to our day 3 of hearing 7, and welcome to our witness. I'll just give you a little bit of time to settle yourself. While we've just got this pause, can I check with the Crown whether and coordinating counsel about the situation in relation to Mr. Stocks?
I understand that there has been no objection to him giving evidence tomorrow afternoon in place of Willie John Martin, but I guess Claimant Counsel can correct me if I have that wrong.
Right, and Mr. Martin is able to...
Yes, he is able to move into the 25 May week.
Kia ora, thank you. And coordinating counsel, is that all settled and agreed? I think, Mr. Sharp, you're the only coordinating counsel online at the moment.
Sorry. Ma'am, I saw the exchange of emails, and Mr. Lyle in his email noted there was no objection. So I take it from that there is none.
All right, so we'll accordingly change our timetable to fit in Mr. Stocks. All right. Now, welcome. Nau mai, haere mai ki te rōpū whakamana I te tiriti. Welcome to our hearing. What I'll do first is hand you over to your counsel to introduce you, and then we'll begin your evidence.
Tēnā koe, Ms. Casey. Welcome to the inquiry. By way of formalities, can I first ask you to state your full name to the tribunal?
Kia ora koutou. Apologies for being a little bit late, I got lost. I am Katrina Eileen Casey.
And can you confirm that for the purposes of this inquiry, you filed a brief of evidence dated the 29th of September 2025?
Yes, I can.
And my understanding is that you've also prepared a summary of your evidence which you intend to present this morning, correct?
Yes, that's correct.
Can I invite you to present that summary to the tribunal?
I am Katrina Casey. My evidence relates to the work that I led in a previous capacity as Chief Executive Cyclone Recovery, which was established as a temporary role following the North Island weather events in early 2023. The 3 events that it refers to are the Auckland anniversary weekend flooding and cyclones Hale and Gabrielle. Together, these events affected in very short order about 90% of the North Island to one degree or another. 15 people lost their lives, thousands of people were displaced from their homes, and there was widespread damage to infrastructure, land, residential properties, power, communications and roading. The most severely affected regions were Auckland, Tairāwhiti and Hawke's Bay. The approach to recovery, the government agreed to requests that regions made in the immediate aftermath of the events that the recovery should be locally led and centrally supported. The government also adopted in principle an approach to build in resilience and build back better. It was very clear very early that the regions would need considerable financial and non-financial support for the recovery. While the regions worked to establish the extent of the damage, central government worked to put in place a framework to guide the Crown's support, both financially and non-financially. The impact in the regions differed, even in the 3 regions that were most affected, and each region's emphasis on aspects of the recovery differed. This is particularly the case of urban and rural recovery. The government working with the regions and insurers developed a framework aimed at categorising severely affected residential property. Using this framework, funding agreements were negotiated with the 3 most affected regions, Auckland, Tairāwhiti and Hawke's Bay. The agreements covered a 50-50 cost share funding approach to voluntary buyouts of the highest category residential properties, flood mitigation works to protect residential communities, as well as Crown funding for local road repair. Together, these cost-sharing agreements involved 1.7 billion of Crown funding. Separately to the funding agreements, based on bids made in Hawke's Bay and Tairāwhiti, the government provided funding for sediment and debris removal. Capability boost was offered in terms of funding across all of the regions affected, and that was to provide expertise and additional resource over a longer period to assist councils to manage the recovery process for the regions. Funding was provided to other affected regions for flood mitigation, infrastructure repair, and also, as you would expect, funded state highway improvements across all of the affected regions. Future of Severely Affected Locations, or FOSL as it became known. On the 1st of May 2023, the government announced a 3-category residential property risk framework. Regional councils and unitary authorities were responsible for assessing and categorising residential properties under this framework. This was based on the future risk to life and residential properties from a significant future event, focused on flooding and landslides. The policy framework was bespoke and applied only to properties severely affected by the Niue events, not events before or after those 3 specific weather events in early 2023. Residential properties in Category 1 did not have any risk to life and only required repair to their previous state. Owners of these properties could work with their insurers with no intervention from either local authorities or the Crown. Residential properties in Category 2 had sustained significant damage and a risk to life was assessed. However, mitigation of that risk to a tolerable level was possible at an individual level, for example, lifting property, drainage, or at a community level, for example, building improved or new stop banks. Residential properties in Category 3 had sustained significant damage and a risk to life was assessed. However, there was no mitigation feasible for these risks. Owners of these properties could enter a voluntary buyout program. Local authorities managed this program of work and became the owners of the residential properties that were bought out. Beyond the categorisation framework itself, all further policy decisions to give effect to it were made and implemented at a local level, not by central government. All affected regions were invited to enter the categorisation and voluntary buyout program, where central government would meet 50% of the costs. The number of voluntary buyouts made were over 1,200 in Auckland, 70 in Tairāwhiti, 180 in Hawke's Bay, 12 in the Masterton District Council area, and 6 in the Tauranga District Council area. Whenua Māori and Marae relocation pathway. This pathway was developed to specifically ensure that there was an opportunity provided to enable those on Māori land to move out of harm's way, and in recognition that the characteristics of whenua Māori were different to those owning residential properties covered by the voluntary buyout scheme implemented by local authorities. The pathway also recognised that, as well as being important taonga and deeply valued intergenerational cultural assets, when Māori land is subject to intergenerational and often complex interests, a unique legal framework and specific protections arising from Te Tiriti o Waitangi and legislation, in particular the Te Turi Whenua Māori Act 1993. This pathway focused on Category 3, residential whenua blocks, marae, and assets of cultural significance, such as urupā. Marae were included because communities would risk suffering harm to well-being and cultural identity if they had been categorised as Category 3 but had no support. Engagement occurred with iwi to help shape the pathway. The themes from the engagement period were built into the pathway. The themes that came through in that engagement were many residents wanted to remain as close to their whenua as possible. Relocated sites needed to be within their hapu takiwā. Property buyouts were not appropriate, and ownership of whenua Māori should not change hands. There was, however, an openness from iwi to grants. Different challenges and complexities for each location lent themselves to bespoke solutions. Marae trustees and post-settlement government's entity leadership sought support from the Crown for facilitation and resourcing. Owners, whānau with Category 3 properties would require advice and navigation support from the Crown to help them understand their options. If officials were clear that given the untenable risk to life, continuing to live on Category continuing to live on Category 3 land would not be appropriate, but that the land could be used for other purposes so that alienation from the land did not occur. Discussions with Marae trustees in Tairāwhiti formed the basis of the recommended Crown package for Marae. Engagement focused on Marae identifying their own suitable safe sites to relocate to, working with Marae trustees to work through the likely costs in light of the sites selected and the Crown parameters to determine the nature of the package. Establishing a framework for the ongoing trustee and Crown relationship to govern the Marae project. Trustees navigating discussions with whānau to seek support for the Marae to move and taking the appropriate action through the Māori Land Court to support the proposed move. finalising the Crown funding through a tripartite relationship and funding agreements reflecting the roles of the Crown, Marae trustees and National Infrastructure Funding and Financing Limited, NIFCO. Decisions were made that the implementation of the pathway would be led by the Chief Executive of Cyclone Recovery, supported by the unit that had been created. Initially, the Crown set aside $75 million for implementation of the pathway, an amount that was initial and considered initial until it was known which marae and whenua Māori were categorised by regional and unitary authorities as being in Category 3, and approximate costings could be done. The Crown added a tag contingency, and in early 2025, the final resource needed and provided by the Crown for the full implementation of the pathway was determined. The total resourcing was $136.215 million. In terms of the process, the Gisborne District Council and the Hawke's Bay Regional Council were the only two local authorities within the regions affected to categorise whenua Māori and marae as Category 3. This automatically qualified, no questions asked, by the Crown, those categorised to go into the pathway that we were responsible for implementing. We were responsible for forming and negotiating the relocation packages, as well as ensuring prompt payment of any grants that were agreed. At all times, entry into relocation negotiations and/or completion of these processes was voluntary. 5 Tairāwhiti and 2 Hawke's Bay marae were categorised as Category 3. I led the process with the Māori trustees of the 5 Tairāwhiti marae, and Te Arawhiti, the Office of Treaty Settlements, led the process with the PSGEs, who were responsible for the 2 Hawke's Bay marae. Te Arawhiti also led the process for relocation of a papakainga associated with one of the Hawke's Bay marae. When the basis for the agreement with the PSGE for the papakainga was completed, we took over, concluding the funding agreement negotiations and making the associated payments. Gisborne District Council identified 10 residential Category 3 whenua Māori properties, and the Hawke's Bay Regional Council 14. The Hawke's Bay Regional Council identified 2 further properties containing cultural assets, in both cases urupā, that were also eligible. I assumed responsibility for all aspects of the pathway implementation when whenua Māori was identified as Category 3. This included engagement with owners of whenua Māori, negotiation and approval of residential relocation payments, payment of legal costs for owners, payment and arranging for valuations, payment of relocation grants, and payment and arrangement of the demolition of any remaining residential structures. The process was voluntary and took as long as owners wanted or needed it to. Agreements were secured with all eligible whenua Māori owners, and they and the papakainga grants were paid out by the 30th of June 2025. As part of the agreements, for safety reasons, residential structures had to be removed or demolished, services capped, and septic tanks removed. We did make bespoke arrangements where requested, for example, leaving structures such as a shed to store tools, depending on how owners thought they might want to use their whenua. In total, we were required to demolish dwellings and related structures for 8 residential properties, ensuring the owners were part of determining the statement of work, so they could retrieve anything they wanted to. For other properties, dwellings had either already been moved or were to be relocated, or owners chose to manage the demolition themselves. Marae relocation. After Te Arawhiti had completed negotiations with the two PSGEs for the two Hawke's Bay marae, we took over completing the relationship and funding agreements and putting them in place. We led all parts of the process with the marae trustees for the 5 Tairāwhiti marae. We did not underestimate the significance of a decision being made to relocate the marae and the time that it would take. In all cases, they did make the decision to relocate, and they had all acquired new sites before agreements were signed. Ownership of existing sites remained where it was. The Crown had no role in the planning, design or building processes. Marae trustees retained full responsibility for all aspects. NIFCO works with the marae trustees to develop project schedules which include the key milestones for payment, and they are also responsible for monitoring and reporting against those delivery plans to the Crown. I appointed a Crown representative to each project control group. It is the same person for all 7 marae, and this was an appointment I sought marae trustees' views on before making it. The Chief Executive Cyclone Recovery role and the supporting unit were disestablished on the 1st of July 2025, and residual responsibilities transferred to the Department of Internal Affairs. And just some concluding reflections. This was, from the start, an ambitious program, and there was at times a difficult balance to strike between ensuring safety to life while recognising the significance of people deciding to relocate away from their whenua. We were a small team, and I know at times the work weighed heavily on the team as they saw the unsafe living conditions many, often elderly people were living in, but needing to provide the time and space for decisions to be taken. We chose to ensure that time and space was given and attended as many meetings in people's homes or wherever they wanted as they needed. We drew a line on the Crown's offer in a very small number of cases where there had been substantive time allowed, and particularly with the approach of winter and our concerns about safety. We were flexible so that when requests were made for extra time to relocate a residence or to retain some structures on site because owners were thinking about growing a nursery or vegetables or just wanting to spend time. Equally, we ensured that the contractors undertaking the demolition were flexible and the owners were involved in setting the statement of work, so that if they wanted to take some parts of the dwelling to a new site, or, as in one case, retaining the roofing because it was relatively new, or in retrieving buried material and taonga. In many ways, the decisions for marae trustees were of a much larger scale and at times more difficult because of the wider impact. Part of giving them space was to ensure that none of them were publicly identified or funding talked about publicly. We were available to support the marae trustees with information, helping to see what was possible, while working through the nature of the funding that they would have access to. It was important they had access through this process to funding for legal advice and hui costs. The marae relationship and funding agreements recognised a Crown contribution to purchase a new site and an immediate payment on signing that enabled them to get everything underway. Importantly, it was recognised that the relocation process would take considerable time for marae trustees, so a grant was made on signing of $400,000 for marae trustees' administrative costs throughout the process. Early in the process, we contacted the Māori Land Court, who offered to set up a joint working party. This was extremely valuable, as was the time and attention given by the Māori trustee, particularly concerning some of the more complex properties. We were well supported by ministers in both the current and previous government and had a seamless transition between the two for this work. While the policy and nature of the pathway were decided by the previous government, the current government supported the pathway and provided the additional funding needed to complete the program. My biggest reflection is the importance of establishing a relationship, developing trust, and taking time to understand the story behind the people and their property. If we had approached this work as contractual and transactional in nature, there may have been a far less satisfactory outcome. I had a special team. It wasn't big, but each person went the extra mile on this mahi. We did get the appropriate outcome for owners of the 24 whenua Māori properties and the 7 marae. That secured people's safety and retains the ownership and connection to the whenua where it belongs. For each of the marae, playing a small role in their protection for future generations will be something I will always point to as one of the achievements I'm most proud of. Thank you.
Kia ora, tēnā koe mō tō kōrero. We now have questions from Claimant Council, and our first questions are from Ben-in-law.
Kia ora. Thanks for your evidence, Ms Casey. I'm representing 3 claimant groups. One group is in Mangatu, up in the Bay of Plenty there. Some issues with roading up that way and storms. One group's around on the Taranaki side, Parihaka sort of area. They've had their troubles there, and the others down in Kapiti. But thank you for your evidence. Yeah, it's quite profound, the work you're doing. So it's much appreciated. I was particularly struck by the comments at 81 and 82 of your evidence, where you're talking about trying to get as many meetings as you could with people in locations, and it weighing heavily on your team that you saw people living in unsafe conditions, and you know, after the main events and staying on the properties. But I guess my questions start at paragraph 32, 32.5, and this sort of the framework of my questions. You're trying to ensure alignment with wider policy decisions on long-term resilience, climate change and managed retreat. So in some ways what's happening here potentially gives us some signals about what we might be doing more of in the future. That was something that people were alive to, the government was alive to.
I think I'd make 2 observations about that. That statement is in reference to what the previous government had in play at the time. So concurrently with this work, the previous government was working on a wider framework, more of a management retreat framework, and what we were trying to do there was to make sure that anything we did in response to this specific situation didn't get in the way of what the government was planning to do. So it was really a matter of keeping abreast of what the agencies that were carrying that work out were doing. And in fact, the core policy around this work was developed by the same agency, Ministry for the Environment, that was doing the wider policy work. In terms of your second point about whether what we did informs some of that wider work, I think there are particular considerations in the sense that every recovery response should be considered in terms of the situation that it was in. I would say that whatever happens with policy going forward, that particular care and attention needs to be given to the questions that we were seeking to answer, which is that the kind of policies that you put in place for, if you're thinking about residential urban areas, would be different, and there needs to be different consideration when you're thinking about whenua Māori and marae and cultural assets.
Okay, and so can I, yeah, and when you say the wider work, I'm aware of this, there was a report in August 2023 of an expert working group on managed retreat. You familiar with that document?
We were at the time, but of course the government changed.
Okay. So
shortly thereafter.
Yes, and I guess we'll make submissions on where we think that's got to. But can I look at looking at what was done, because it is really interesting when you look at the details of what you had to grapple with. And I'm particularly interested in two things. One is the Auckland, but we'll get to Auckland in a minute. But before that, I want to look at whenua Māori, the 24 properties, residential, should we call them residential Māori properties, and you got 8 of those, eight people relocated across to a Papakainga proposal, and I presume the 16 others then got relocation grants, went to another place, but kept their whenua Māori.
Correct.
Right. And then they remain able to go back to that to the whenua, and I think you said some of them might be wanting to nursery, grow vegetables, simply spend time back on the land.
There was one condition associated with the relocation grants, and that was that they would not reside, or for want of a more colloquial term, they would not sleep on the land. But the land is theirs, they can do what they like with it apart from that. That was the only condition, and that is the reason why we moved to demolish residential structures.
So, a couple of things there. So, are these 24 properties all actually Māori freehold land properties? Do you know?
I'm assuming so.
Well,
Sorry,
all right. Okay, we can.
Yeah, I don't have the detail on that.
Okay. So people got a relocation grant, but they're keeping the land. So they're getting. They're not getting paid for the value of the land and buildings. They're just getting a sum for them to relocate. So is the sum that they get to relocate, they're allowing them to pick up another property somewhere, so it's large enough for that?
Absolutely. So the two things were different. So the voluntary buyout of the property was like a sale, as we would do in any residential selling situation. On the whenua Māori side, the aim was to get people out of harm's way. And that meant that when we were looking at the figures and how to come up with something appropriate, it needed to take into account their ability to actually be able to secure another property. So it was not the same formula that was used for residential properties. We did do a valuation, but within the policies that we were working within, we had minimum and maximum figures that we were working to, depending on the situation of the residential property. In all cases, the grants were enough for them to relocate somewhere appropriate.
So this is interesting because you're not purchasing the property and people getting a sum that they can take somewhere else. So how do you decide what the level is? I mean, if people say, well, I actually want to live somewhere in Auckland, do they have to, they got a sum suitable for relocating somewhere close in a residential property? Was that sort of the general approach?
I mean, most people didn't want to leave, their land. So I'm not aware of any of them that have sought to relocate in Auckland, for example.
Right.
So we did do a valuation on each of the properties. That formed the minimum payment, but we didn't pay anybody the minimum payment. That's a lot to do with the state of the properties pre the events. And we applied some guardrails and formulas on top of that to get to a maximum level. We took the maximum levels through to joint ministers to get approval that we could go up to that level for each property, and then we sought about talking, more closely with the owners. From memory, there is no situation where owners questioned the quantum. It wasn't really a negotiation in that sense. There was certainly, we did do quite a bit on where people wanted more flexibility for what they were doing. So I can think of a couple of occasions where owners wanted to move the residents sort of almost down the road to another piece of land that they owned that was not Category 3, for example. But yeah, there is no situation in which they weren't able to relocate to their place of choice.
And when you say no one questioned the quantum, should we assume generally that means that a generous approach was taken?
Yes.
Okay. And just
an appropriately generous
appropriately
approach.
generous.
Yeah.
I'm not suggesting it was. You weren't purchasing apartments in Auckland for people. That's what I
We
assume
weren't doing any of that. So the other thing to note is that at no time did we specify what they had to spend the money on. So there were no conditions on what they did with the relocation grant. It was simply that you cannot sleep on this site, and we'll take the residential structures away so that you can't. That was the only condition. So we didn't follow up with them to see what they did do, but we know they're not sleeping on the land, as far as we know at the moment.
Oh, that's interesting. So some people may have taken cash and then just simply used that not for another property.
Well, they have to.
It might have given them another property, but.
Well, they have to live somewhere, but you know.
But they can apply it how they feel.
Yeah, but it was not our call to work out what they should do with the funding. What we were interested in was getting them out of harm's way and doing that in an appropriate manner that would mean that they were able to move on with their lives. I know of at least one very elderly person who relocated to a retirement village, for example. And I would hope that they were able to get a better standard of retirement village than what they might otherwise have got.
Yes, I was going to say that sounds like you were taking an appropriately managed but generous approach. That sounds interesting. In terms of the properties that whenua Māori that remains, people still have full ability to treat that land, for example, lease it for cropping purposes or some other or something glamping or something. Oh no, it can't be glamping.
No, can't be doing that.
But some sort of non-residential purpose and possibly even amalgamating with other blocks or selling it, that sort of thing.
They can do what they like as a property owner. I think it would be highly unlikely they would sell it though.
Yes, I understand. Well, if it's whenua Māori, that could be interesting. But and then just lastly, I wanted to ask you about the Auckland situation, because I'm intrigued by the fact that quite a different approach in Auckland, where you've got 1,200 properties, and this wasn't something you were dealing with. But you're aware of that it is part of your approach?
We were closely working with them.
Right.
Auckland did not identify, did not categorise any whenua Māori or marae, and we did test that by looking closely at the areas that they were identifying for voluntary buyouts, and they were intensely urban areas. So, yeah, we have no reason to doubt their assessment of that.
And my question, I guess, that I've raised with others is, do we know anything about whether any were there were rental arrangements with any of those properties, and whether there was a Māori population affected in that way?
That would be a matter for Auckland Council. The Crown didn't get involved in that. But of course, given the areas, yes, there would have been rental properties, and there would have been Māori living in a range of properties. Equally, there would have been Māori that owned properties.
Potentially, yeah. Okay.
Well, actually, I think that would have been the case.
Right. But it wasn't felt appropriate, or it's seen in a different light to be in an urban situation?
The key distinction was whether it was whenua Māori or not. The land.
All right. So it's the land
Yep.
title. All right. And so going forward, I see the government's cancelled a $6 billion resilience fund, and it says it's now taking an approach, a standard budget approach, I think is the words that are being used. So are you still working in this area, in any sort of managed retreat, or not managed retreat, but any recovery areas, climate recovery areas now still?
No, I am currently looking after the local government functions in Department of Internal Affairs through to 30 June when they transfer to the new agency. But apart from that, the whenua Māori, the only part of that we still have is the completion of the marae rebuilds, relocation, which will be probably another maybe 12 to 18 months. And do you know this managed retreat report that I referred to earlier, the expert working group on managed retreat, which I see Dame Sian Elias and Sir Terence Arnold were involved in. Do you know is the government taking that any further, what they're doing with that report? I think that report was the previous government.
Yes.
So you would need, for what the current government is doing, you would need to perhaps talk to Ministry for the Environment, who would lead the policy in that area.
All right. Thank you very much for those answers. That's very helpful. And again, thank you for your work.
Thank you.
We now have questions from Woodward Law. Mr. Sharp.
Thank you. Ms. Casey, just checking you can hear me.
Yes, I can.
Yeah. My name is Michael Sharp. I'm representing a number of claimants in this inquiry. I've only got a few questions because Mr. Benyon's covered most of the areas I was going to cover. And they're just really questions of clarification. So you said at paragraph 26 of your summary that the final funding provided by the Crown for the implementation of the pathway was $136.215 million. So can you just confirm with me, has that funding all been spent?
Absolutely. There is some contingency funding left for the marae rebuild, but I suspect with what's going on at the moment with fuel and the fact that the marae are in challenging places to get to, that funding will be fully used. The funding split into about all of the residential funding was spent by 30 June 25. All of the Māori funding was allocated by that time as well. And we have been asked the same question by ministers, whether there's any funding left over, and I've said no.
And in as far as the Crown involvement with the works, or whatever happens with these pathway projects, that the Crown's finished their role in those projects now?
The 7 Māori are in the process of rebuilding on their new sites. We have a Crown representative on their governance arrangements. We appointed NIFCO to hold the payments and also provide some specialist support for Māori trustees, and also to do much of the monitoring and reporting. So they, in a sense, do perhaps what the Crown might have thought it should do in past, but the Crown has no particular expertise in that area.
So to just unpack that, so there's still ongoing Crown involvement with overseeing, involvement with the work, overseeing or monitoring, that sort of thing? Is that what you're saying?
Not on the residential side. That was done and dusted on by 30 June 25. On the Māori side, there is, as I say, a Crown representative on the project control committees through until, I guess, they reopen and are finished. But that is not to have input into design and so on and so forth. It is basically to protect the significant investment, make sure that Māori trustees get what they are paying for, or we're paying for them.
And of those Māori, how many are in that state where the work is still going and the Crown's still involved?
Oh, they're all in that situation. So most of them are in the stage of doing site works. They've all done their plans and so forth. So yeah, and their designs as well. Some of them, before we had made the final offers to them, were very proud to show us the designs they'd already done. So, some of these have been, twinkles in their eyes, some of their eyes, for some time, but the difference being that they would have expected to rebuild on their existing site.
And just another point of clarification, you said there was no dispute about the amount of funding, but was there any issues or dispute about eligibility for the pathway?
No, and that is, as I say, the regional councils were responsible for categorising the properties. We took whoever came into the pathway. We didn't question that.
Thank you, Mrs. Casey. That's all the questions I have.
We now have questions from Phoenix Law.
Tēnā koe te kaiwhakoa, tēnā koe Ms. Casey. Ko Ms. Boatwright tōku ingoa. I represent several claimants within this inquiry, predominantly based in Te Taitokiro, but all over Te Kao Māui. Now, throughout this inquiry, we've heard a lot of evidence from Te Taitokiro-based claimants that the significant cyclone events such as Gabrielle... Can you put down?
Sorry. Throw it out.
It's okay, that's all ka pai. That the catastrophic events of Cyclone Gabrielle and the likes thereof, of those natural disasters, had quite significant impacts on whānau, marae, hapu, iwi, up in Te Taitokiro. But comparatively less focus of those impacts are given in your evidence. Is there any particular reason why?
So first to acknowledge that, yes, events over time are having a significant impact in Te Tai Tokerau. The councils in Te Tai Tokerau decided not to enter into the categorisation program, which meant that there were no Category 3 marae or whenua Māori identified by those councils, which was the gateway into the program. However, we did have access to other funding, which we provided support to a number of marae in Te Tai Tokerau to put some flood protection in place. And yes, we were conscious that there are a number of marae that the impact of multiple events and subsequent events and events before means that over the next 10 to 30 years, they are likely to be in a situation of managed retreat. But for these particular events, the decisions of others meant that there weren't any that were affected in a way that would need to be relocated.
Okay, thank you. And when councils made these decisions not to, in particular in Te Tai Tokerau, was that questioned by yourself or your team as to why they're not considering the wider impacts that climate change or these events have had on Māori to not be involved?
So the issue that, or the parameter that we were working within was those three events. And if there was not significant damage and there was not a future risk to life from a similar event, flooding and landslides in that situation, then they wouldn't qualify, even acknowledging that subsequent to those three events, there were multiple other events that occurred and beforehand. So both governments had made the call that this was a particular response to three particular events, notwithstanding that I think everybody recognises there are some bigger ongoing issues, particularly in Te Tai Tokerau.
Kapai. Now, I just wanted to move to a comment that you make at paragraph 39 of your summary. And I just wanted to explore that a little bit further, where you state that you sought out the advice of Māori trustees in selecting a Crown representative to sit on project control groups. Did Māori trustees also have the opportunity to recommend people as based on perhaps maybe a selection list to be their preferred representative, Crown representative?
Some had approached me about the particular person who is the Crown representative, but there wasn't really a need to ask, given that it was a very popular choice.
Of course. And just moving to a response that you gave my learned friend Mr. Benyon earlier in relation to the implementation of guardrails, what particular guardrails did you implement when choosing, I wouldn't say choosing the negotiation or monetary value, but the monetary value? So
the policy parameter to get the maximum level that could be possible was 2 times the land value plus 3 times the improvement value of the land.
Thank you. And just turning to paragraph 51, just quickly, of your main brief of evidence. You explained that officials considered it inappropriate for people to continue living on Category 3 land due to the untenable risk to life, but there was a desire to allow continued use of that whenua for other purposes, so that hapu were not alienated from it. Now, when this was put to whenua Māori or Māori, the approach was put to Māori, what was the reaction like where you would tell them that they can retain ownership of their whenua, but they can't live on their whenua?
I think most had been through a pretty terrifying experience, and in some cases more than once. There was pretty widespread coverage by the time we got involved in terms of the processes that councils were going through. So there was some awareness that there was an assessment going on as to whether there was any risk to life. So the reason why they can't live or is really about sleeping. So the concern is about nighttime, to be honest, and on the basis that anyone who is working the whenua or doing something with it would be able to move pretty fast, should it be cyclone conditions or whatever, or that they don't have a reason to be there in the middle of a cyclone, for example. But unfortunately, in most of these situations, most of the scary or real risk to life occurs when people are sleeping, and not necessarily having the awareness that you have when you're awake. So that did take some thinking because it was voluntary. While we were saying that the council had assessed a risk to life, that was intolerable if they stayed there. They could stay there if they wanted to, but they wouldn't receive any assistance from the Crown in terms of a relocation grant if they chose to do that.
Ka pai. Well, tēnā koe, Ms. Casey, nā mihi mō te kōrero, mō te awhi o te kaupapa. That concludes my questions for you. Tēnā koe te kaupapa.
Now have Ms. Te Whenua.
Tēnā koe mā, nā mihi nui ki a koe, o tira ki a koe anō hoki, Ms. Casey. My name is Ms. Te Whenua. I'm a representative of two claimant groups. One is Te Arawa Climate Change Committee, and the other is Ngāti Uepo Hapu within the Waiapu catchment of Te Tairawhiti, who you may be aware of as they were quite heavily impacted by the severe weather events of 2023. And I think, I gather that a number of them marae have been impacted as well as lands with categorisation of whenua in that rohe. So it's a pleasure to be able to ask you questions on their behalf today. My questions will pertain to both your former role as the Chief Executive Cyclone Recovery, which the majority of your evidence is regarding, but also with respect to your insights as the present Acting Director, Deputy Secretary, Local Government, and Executive Director, City Regional Deals within the Department of Internal Affairs. And just as a heads up, especially for our registrar, I'll be referring to the brief of evidence of one of our core witnesses, Dr. Sean Awatere, which is appellation A80. And I also wanted to acknowledge the severe weather events themselves, which heavily impacted, as you note in your evidence, the rohe of Tāmaki Makaurau, Gisborne, Te Tairawhiti, Hawke's Bay, Masterton and Tauranga. I can remember back in that time, we all felt aroha for the severely impacted rohe. And now there's no rohe that remains untouched from the severe impacts of extreme weather events within Aotearoa. Would you agree?
I think it's a growing issue right across the country, yes.
Aye. And on that note, with respect to the growing nature of the issue, the significance of the issue, and as it continues to grow more and more significant for all Aotearoa and all Māori, I'd like to refer to your paragraphs 27 and 28, where you talk initially about the underpinning core decision making that was made and which led to categorisation of whenua. They're highlighting that local communities, this is your paragraph 27, including local government, asked for the recovery to be locally led, recognising the importance of local knowledge and input into decision making in the recovery, especially from previous events and previous experience. And then at paragraph 28, you note that the locally led you again refer to locally led, centrally supported recovery. And at the last sentence of your paragraph 28, you say that the initial phase of recovery, central government made decisions, in the initial phase of recovery, central government made decisions on a policy framework for councils to use to consider severely affected residential lands were made. So my question is, am I correct in thinking that at that initial core phase of decision making, the core decision makers were central government and local government?
Not quite. One of the first things that the government had done was to set up a cyclone recovery task force, which was chaired by Sir Brian Roche. That task force had representatives on it from iwi leaders and a range of other people. It was tasked, and Sir Brian was tasked with being out in the regions and also working directly with insurers to identify what kind of policy responses might make sense. And at the same time, funding was being provided for local authorities, but in the case of Tairāwhiti, for each of the iwi received a grant to support their recovery efforts in that sense. So government had to make a call or nothing would happen.
Thank you, I understand. So central government made the call?
After considerable consultation, yes. And that was just on the categorisation framework and what stemmed from that, given that significant Crown funding was necessary. So that ended up just for the framework, executing the framework, and then subsequently the Whenua Māori pathway was the $1.7 billion of Crown funding.
So central government made the call on the categorisation of
It
land?
made the final call, yes, but it sought views of a number of parties, and the task force was permanently out in the regions affected, undertaking that work.
Thank you. Now I'll refer to paragraph 56 of Dr. Awatere's evidence. Someone may be able to bring it up on the screen, but if not, I'm happy to. Oh, here we go. 56. Dr. Awatere is himself a descendant of Ngāti Ue Pōhatu within the Waiapu catchment area on the east coast. And so he has lived experience of the severe weather events and also as a thought leader with respect to the impacts of Māori on climate change. And at paragraph 56, Dr. Awatere is critical of the emergency management regime and that It does not uphold te tiriti principles of co-governance. Would you agree with that?
I'm not familiar with the emergency management legislation. That might perhaps be a question for NEMA to respond to.
Hei te pai. He says at paragraph 65, that a key aspect of Crown policy in its devolution of climate adaptation and resilience responsibilities to local government is that it's without adequate support, funding or treaty-based accountability frameworks. Would you agree?
Certainly not in the work that we were doing. I would draw a distinction between recovery in response to a significant event, which requires immediate policy and action, and forward-looking managed retreat or climate adaptation policies or regime that perhaps have a much wider set of responsibilities and lenses.
Does that set of... Sorry, continue.
So our focus was these terrible events happened. The recovery was complex, long, and different from many of the recoveries of the past. It was the first significant set of events that affected multiple regions in a very large way, and it required a bespoke policy in terms of what existed before that time.
Yes, and I understand where your evidence mainly focuses on managed retreats, correct?
Only focuses on those three events and what policies were put in place for the recovery of those events. The policies were not intending to be precedent setting.
No, but the idea around them is managed retreats, correct?
After a significant event and where there is a risk to life that is tangible and real and identified.
Thank you, I appreciate that. I guess what Mr. Awatere's or Dr. Awatere's evidence is alluding to is we're trying to understand managed by who.
Sorry, I'm not sure I understand the question.
That's okay. I think if I continue to paragraph 52 of Dr. Awatere's evidence, here he's talking about what co-governance or even Māori-led solutions can look like. And at 52, he notes that in the context of whānau lived experience, Crown emergency response systems often fail to provide timely or culturally appropriate, being the pertinent point here, assistance to Māori communities. And at paragraph 70, sorry to move you around, Dr. Awatere posits that Māori-led solutions offer a more constructive, proactive adaptation pathway grounded in tikanga and kaitiakitanga. Were Māori-led solutions considered in the specific nature of the response that you oversaw?
We didn't oversee the response, we oversaw the recovery, and I can say that there was iwi and Maori trustees and others' involvement in each part of the picture and each step of the way that we went through it.
Did they co-design the the solution?
I don't know that you would call it co-design, but basically from the point at which government had decided that it couldn't in all conscience leave people to reside on whenua where they had a risk to their life, how that happened and what happened after that was it was a partnership at that point.
And of course, because by that point, the solution had already been decided for them, hadn't it?
It's hard to see what the option would be if you've got a risk to life on a residential property. You know, in that situation, the Crown determined that it should offer an option that gets people out of harm's way and gives them the means to move on.
Thank you. And were Māori offered an opportunity to put forward their options, grounded in mātauranga Māori, tikanga and kaitiakitanga?
They were certainly asked, which is where we got the reflections from in terms of the work the task force and others did talking to iwi, and as I said, iwi leaders had representatives on, as did local iwi, on the task force. So their reflections that the model that was being put forward for residential properties would not be appropriate for Māori, I think is very much steeped. And the response the government gave as a result is very much from Māori.
Sorry, you said that the response that the government gave was from...
So the government made a call, having got the feedback from those processes and with the reflections, that its policy to buy out residential properties would not be appropriate for the whenua Māori and marae pathway, and it needed a bespoke set of policies.
On that point that you just made, that the response that the government made, or the decision that the government came to, was from Māori, would you be happy for me to put questions in writing just to demonstrate the extent of which Māori drove that decision?
I wasn't closely involved in that. I'm not sure that there's anyone left who can respond to that. But I can say that I don't recall in our interactions with the task force and with the iwi leaders, and then subsequently with local, those affected, that there were any alternatives or concerns raised, and at no time were there concerns from individuals or the marae trustees that we were inappropriately responding to them, putting people under pressure, or that there was an alternative to the Crown providing payments for people to move on.
I suppose in your response to questions from my learned friend, Mr. Benyon, and I'll shortly come to an end, I've only asked for a certain amount of time to question you this morning, but in response to your to a question from my friend, Mr. Benyon, you said most people didn't want to leave their land. How significant was Māori resistance to these managed retreats?
I don't think it was significant. I think everybody had to go through a process, and that process needed to take time. Owners needed to work through for themselves. Because it was voluntary, they didn't have to go. Some of those decisions took some time. We didn't pressure them. We just made sure they had the information. We made sure that we funded them to have appropriate advice where they wanted legal advice. And we made sure that they were fully aware of what it was that the Crown would be offering, and could then think about the options that gave them. But at no time was there a situation where anybody was saying that they had to leave.
I'm just interested in that response because the categorisation of their land had already been made, categories 1 to 3, correct?
Yes. But again, the same procedure for categorising residential property was used, and that process was voluntary as well. Nobody had to sell their properties or agree to a relocation grant. No pressure was put on them to do that.
I appreciate that, but if they were under a Category 3, am I correct in that they could not occupy the land, or the land was deemed unoccupiable?
No, they could, if they were a Category 3 and they chose not to accept offers from either the local authority offer or the government's whenua offer, then of course they could stay there. They were making a choice about continuing to live where they lived or accepting the risk that went with that, or accepting one form of payment or another to relocate.
So at paragraph 42 of your evidence, it states Category 3 areas, that the program reduced the intolerable risk to life from any future significant flooding or landslide events in Category 3 areas by ensuring the land could no longer be used for residential purposes.
So that is if that would take two forms. One, if they accepted payment to move, and two, if they then sought, if they decided to stay, but they sought consents for further building, then the council wouldn't give them any future consents to do so. But their choice, they can stay. They had a choice to accept the risk, and I guess the consequences of doing so.
But council wouldn't give them future consents. Thank you very much, Ms. Casey. I appreciate your time. Thank you, ma'am.
We now have questions from Mr. Lyle.
Te kai whakaua. Mōrena, Ms. Casey, I hope that you can hear and hopefully see me okay, and apologies for not being there in person. My name is Bryce Lyle, and I represent some of the claimant groups in this inquiry, including Ngāti Ruapaniki, Waikirimoana, Tū Pukerehe, Ngāti Pitohi, Hauraki, and a cluster of claimants from Waimate Taimaki, Kaikoui area in Te Tai Tokerau in the far north. I think most of my questions have been covered, and we don't have evidence from the Māori participants in the program that you've described, so I don't think there's much sense in me litigating that with you or running through that. So I thought we'd ask some higher level questions and see if you have a view on process and maybe what could be done better or what was lacking or lessons that were learned. Because I guess the starting point is that the work, the mahi that you've described, was all reactive to weather events that had occurred. It wasn't something done proactively with the future in mind, was it?
It was certainly as a recovery response to the events, but I wouldn't say that it wasn't with the future in mind. It was certainly with the future of the individuals and whānau and marae trustees and iwi in mind. That were affected.
National, yeah, with a view to the national scope of this sort of management retreat or the work that's going to require, though, your task was constrained by that particular weather event, and as we've seen, really the work was finished in mid-2025.
So
that's right,
I wouldn't say we were constrained. We were set up specifically as a result of those three events to lead the government's recovery effort from those events. And when the bulk of that had been done, we were always going to disappear. And the work that we had done, the agencies that are responsible now for policy for climate adaptation were responsible for leading the policy work that we implemented.
Does your view that the institutional knowledge that was developed and created throughout this process is retained by those agencies?
Certainly, all of the documentation is. I mean, people come and go, I guess. Whether the individuals that developed the policy are still around, I couldn't say. But one of the things we were conscious of, which I think two of our group of handover documents were in the bundle and in the evidence, was to make sure that we had documented everything that we had done, and also that there was considerable documentation on the decisions made. I would say that the policy process at the time, the previous government had set up a special cabinet committee for the cyclone recovery, and it met weekly, and it had senior ministers on it with the power to make decisions and act. It was chaired by Grant Robertson at the time, and on a weekly basis the policies were being turned around from that process, and there were a number of papers and cabinet papers which are remain available to those now responsible for the wider climate adaptation policies. As I say, the agency responsible for climate adaptation policy at the time led the policy work and supported the Cyclone Recovery Task Force in the work it did ahead of the policy being decided by government. The current government had made a call in the lead up to the election that it would not disrupt the recovery and the implementation of the policies that had been decided associated with those three events, regardless of whether it agreed or not. It had made that call, and that's really what helped for a seamless change, because the government changed at a very critical time in the work that we were doing, and I can't commend them enough on both sides for that seamless transition.
I was going to ask about that, but I think we have your view. So the next question I wanted to ask, or what I wanted to put to you, was the work that you've done and that you're very proud of, and we don't have evidence suggesting otherwise at all, and so I acknowledge that. But I guess you can't put a price on the location of a marae or the attachment that Māori have to their whenua. But the amount of money that was spent during this process wasn't insignificant, was it?
It was an appropriate amount, and we got what we asked for, having worked out what the circumstances that we were facing would cost. It wasn't insignificant, but it was appropriate, and I think if in order to perhaps test out some of that, then talking to the trustees from the 5 Tairāwhiti marae, they will give you a view on how they found the process and the support that they considered they got or didn't get. Yeah.
Yes, I'm not meaning to suggest that anyone was shortchanged in the process. I think my concern is more if we look towards the future, and the evidence is that these types of events are going to grow more frequent and more severe. If we think of Te Tai Tokerau, for instance, there's literally hundreds of marae, many of which will be in areas which would be susceptible to these events. There's going to come a point without some mahi being done right now and some urgency being placed on this, where it just won't be affordable to conduct the type of process that you've been through and described to the tribunal, isn't it?
Yes, that would be correct.
So do you think that would you agree with me that the disestablishment of the task force or the group that you were leading in 2025 is really letting down those communities that it was set up to serve, and really it would have been a critical point at which that work could have been expanded to start that forward-focused work?
There are agencies with responsibility for that forward-leaning work. We were a particular set of skills to deliver and implement. We were not responsible for leading the policy work that really should sit where it kind of sits. So if I look at the makeup of what we had, it wouldn't have serve any useful purpose to keep us around unless we had something to implement and deliver. So best that, in my view, you don't have multiple Crown arrangements doing little pieces of the puzzle, because that tends to be a recipe for not much happening.
And we'll interrogate those other agencies or departments as their evidence comes up, but I think the very particular set of skills is what we're concerned isn't lost in this process. So how do you ensure that there is continuity there, or the lessons that you learned can be passed on? How does that translate into a future-facing way, I guess, is the point here.
So the main thing that we left behind was a set of what I'll call decision trees to guide government to make decisions about the areas in which it might consider Crown support, based on not just the events that we were responsible for, but also pulling in the Kaikoura earthquakes and the Christchurch earthquakes. And it was a scenario-based sort of lens and set of trees. But that, again, is only focused on making decisions after a natural hazard of national significance. It's not about climate adaptation approach that you would take over a number of years, perhaps in peacetime, as opposed to responding to particular events immediately after the events. No two events have been the same, was based on one of our things. So, our preference would always be that, there is a degree of work that's done around prevention, so that you don't end up having to take the drastic measures in a recovery response to an actual major event. But for those two things to get into balance, I think you've got to be able to predict what's coming, and we'll never be able to predict what happened in Christchurch, for example.
Of those decision trees, there's some information about that in the bundle that you've provided, and I'm looking in particular at, perhaps it's easier if I bring it up so that we're all on the same page, and hopefully you can see it on the screen. So this is document, and in the bottom right for the record is DPMC.002.0522. And in that middle paragraph, we've got the tools consist of decision trees with criteria to respond to 2 questions. That's what we're discussing now. This document is talking about something different.
Yes, that's where the lessons are captured. Translated into a tool that government can use That is a tool that the Department of Prime Minister and Cabinet is responsible for owning and is responsible for leading the advice on its execution to the Prime Minister and Ministers.
My question on that, and this is just taking it from this document and the face of it, is it says it's supported by information from affected regions, including from government agencies, industry groups, the insurance industry, and emergency response teams. Where do Māori on the whenua fit into that information gathering process?
So those that were in the affected regions, we had a very wide consultation process when the decision trees were being put together. They took several months to kind of pull together in that sense. So everyone who had been involved in the recovery was asked for their views. Primarily in the instance of Māori, iwi leaders were involved in that process.
If these are being used in a reactive way after the next weather event, and I'm concerned that is there an explicit requirement built into those decision trees to gather information from marae or whānau, hapu, iwi on the ground?
There is a set within, if there's, so the decisions that government has to make immediately after an event is whether it is an event that is of national significance. So for example, DPMC did an assessment across those decision trees after the January landslide and flooding events, and determined that it wasn't a sufficient sized event to trigger any of the processes under the decision trees, and therefore that the usual responses and recovery that apply through NEMA would be appropriate. So that then tucks you into NEMA's recovery approaches, given that they have the lead responsibility for recovery from the majority of events. So really what the decision trees would be doing is asking government, getting government to make an assessment, do you need to set up a bespoke unit or a bespoke arrangement? Can the existing arrangements that apply in law and with agencies' responsibilities now apply? And that's where they went on that particular event.
Right, well, we'll have the chance to question about, well, once it transfers to NEMA shortly. I did have one more page I wanted to discuss with you, and that's will be the end of my time. If you just give me a moment, I'll track that down. So this is going to be the first document in the bundle, which is the Cabinet paper dated the 1st of June 23, Regional and Māori Flood Cyclone Recovery Engagement Planning. And I am going to scroll down to the page which at the bottom is marked DPMC.001.0008. And really this goes to the question that I think you've discussed with some of my learned friends previously, but it's this inbuilt reliance on the good faith of local councils, or the relationship that local councils have with Māori, and that relationship with risk assessments. So from paragraph 42, which I've highlighted, it says the Crown has an ongoing fiduciary responsibility in its treaty partnership with Māori, which as a lawyer, I think everybody picks up their ears as soon as the fiduciary responsibility is described. But It says on FOSL there are matters which fall to local authorities to take decisions and to lead communication and engagement, such as on risk assessments. And we've seen, or you've described that some local authorities chose not to participate. How do Māori then force council's hand? It seems to me that here the CRU was posed as somewhat of a circuit breaker there. And did that happen, or how were we left with a vast area with a lot of marae, a lot of Māori land being left out of this process? So, because perhaps a local authority thought it might be a bit woke.
I don't know. I can't second guess what local authorities were thinking, but I guess that was the call the government made. We did not play a circuit breaker role. We did not get charged to do that. We did, I can say that those local authorities in other regions, other than the three main affected ones, they were invited by the Minister of Cyclone Recovery in September 23, which was previous government, to be involved, and then the new Minister of Cyclone Recovery, Emergency Management and Cyclone Recovery under the current government, repeated the exercise in March 24, and we did do some work with the Northland Regional Council, because it would have had the primary responsibility, and we did with a couple of councils bring in and pay for some engineering expertise before they made their decision, in order to test some of if they were going to do similar assessments to what the other regions did, whether there would be a need. But that was the extent of it. We were not in a quality assurance role. We were not to second guess local authorities' decisions at that time. That was kind of where the locally led came in.
So if this tribunal was reviewing this process and seeking to make recommendations for a more robust and TTT compliant process for any future weather events, do you agree with me that having a circuit breaker or an ability for Māori to directly approach the central part of this picture would be a benefit to the process overall?
I think it depends whether there is a central process set up or not, because there may not be. But I would think that NEMA probably have those links already for the kind of recoveries that you're talking about. I think the bigger set of questions and the bigger involvement would be more applicable in the wider climate adaptation processes. And yes, there may well be recommendations that the tribunal might make when it comes to recovery from major significant events. But in this situation, there had to be an assessment that there was an intolerable risk to life, firstly, and secondly, the damage had to have been significant. So those conditions in this situation would have had to have been met, and locally it was judged that they weren't.
But we don't have a way to reassure ourselves that there aren't marae or landowners out there who weren't in that position but were just overlooked by their local authority at the moment.
It's not something I can comment on. As I say, we came into the picture once decisions had been made locally.
Well, those are my questions this morning. Thank you, Your Honour.
Thank you, Mr. Lyle. Our next questions are from Ms. Rongo.
Mr. Messi will be asking our questions today. Tēnā koe, Ms. Casey, ko Ms. Tamisi tōku ingoa, and I'm here on behalf of Ngāti Koata. Now, Ngāti Koata are a small iwi based in the top of Te Tauihu, specifically in Whakatū and Marlborough Sounds. Now, there's an island there called Takapōrewa Island, and there is 90% of the tuatara population, and Ngāti Koata are kaitiaki of Takapōrewa Island and tuatara. Now, Ngāti Koata entered into an arrangement with Ngāti Parau to assist in the efforts to re-establish tuatara in their area. However, Ngāti Koata still retain their kaitiaki over the tuatara. And they were translocated from Takapōrewa Island to Tairāwhiti. Now, were you aware that tuatara were in Tairāwhiti?
No.
So there was no monitoring to determine if tuatara were impacted by the cyclone?
Not that I'm aware of.
And they weren't identified in any assessment or iwi engagement, is that correct?
Not so far as what we were involved in.
I just have one final question, and it's in your report bundle, if we're able to pull that up. It's document DPMC 001001. I think it's page 15.
We're just bringing it up.
Oh, sorry, ma'am. It should be page 2 of that. Oh, page 15. DPMC 001014.
Sorry, was that page 2 or page 15?
Page 2 of Appendix 1. Should be page 14. Oh, 50. Yep, that's the one. And I'm just looking at the iwi Māori part specifically, and it's the last sentence. Engagement will also support high-quality Māori Crown relations, including the active protection of taonga Māori, equity and options for affected Māori, and the durability of treaty settlements. Now, would you agree that failing to identify tuatara as taonga species is not active protection?
I can honestly say it was never raised with us.
No, thank you. That's all my questions.
And Loader Legal.
Thank you, Ma'am. All of my questions have already been answered.
Thank you, Mr. Songia. So we're now passing to questions from the panel. And so firstly, Ms. Kapua, do you have any questions?
Thank you, Ma'am. No, I have no questions. Thank you.
Thank you. Mr. Morrison?
Kia ora, Ms. Casey, and thank you very, very much for your submission and the work that you do. Basil Morrison, obviously tribunal member. Of interest is, we understand, of course, in Tairāwhiti that Gisborne is a unitary council, so it has regional council functions. And then you have the Hawke's Bay Regional Council. It is of interest that they took the lead and not the territorials. How did that play out? Did Wairoa and Napier and Hastings and Central Hawke's Bay, etc., did they all say, hand it to the regional council functions to deal with the issues, because it was a, shall we say, I would only use the term water and soil issue, but a lot of it to do with flooding, land use, that are regional council functions. So was it a political decision for the territorials not to be involved and handed to the regional councils to carry out the functions?
I can assure you in the Hawke's Bay situation that each of those local authorities were very much involved. So they had a particular situation where they all agreed to set up a Hawke's Bay recovery agency to coordinate amongst all of them. All of the each of the territorial local authorities signed the funding agreement with the Crown. It wasn't just the regional council. The regional council was responsible for categorising properties, but that was very much done within the governance arrangements that they'd set up for the region. And they were remain responsible for leading a number of the big flood mitigation projects in the region. That really was because the legal statutory responsibilities that each local authority and regional authority had remained responsible for. Nothing was tripping any of that up. I was a member of an overarching governance group across Hawke's Bay, also Tairāwhiti and Auckland separately. And I can tell you that the regional council was not left alone and was never in any doubt about the work it was doing and the significance to the local authorities. Can I say that there were necessary and robust discussions that led to pretty good outcomes for that region.
Really? Does that happen in local government?
I don't think you want me to comment on that.
Okay, just one other issue. When we talk about Category 3 land and for some people who wish to remain on their whenua and acknowledge that they take the risk to whatever, it doesn't negate the territorial council's responsibilities in regards to RMA and building consent if they want to build something on that property. They still have to carry out the shall we say, the usual processes of if they wish to build on it, they have to take the risk, and the risk can be mitigated from the council's consenting point of view of having the building higher than normal or whatever, but it still has to have a building consent.
Oh, just as it would anywhere else. The rules would apply if they've chosen not to accept either voluntary buyout or in the case of Whenua Māori, the relocation grant, and they then subsequently want to make some improvements, residential improvements to the land, they would have to go through a normal consent process. I think it would be unlikely that a council would approve further consents on the property. And we did certainly hear from insurers in the residential areas that, you know, they may or may not get insurance on their existing property with that classification on it.
Okay, third question then. Stop banks and shall we say catchment or flooding issues being addressed by the Regional Council, where new stop banks, breach stop banks are repaired, all of those things that bring up a higher level of protection for, we'll call about this Category 3 land. Does that then, because they have a new stop bank, a higher stop bank, a stronger stop bank, whatever, does that mean that they can go up into a higher level of occupation on that land?
That work, the planning work to work out which communities and individual residences could be protected that way was done before categorisation. Category 3 was determined. So Category 2 is where there is a risk to life. So Category 2 and 3, there are risks to life. But Category 2, the assessment was that we can manage that at an individual property level in some cases by lifting the property, and we could, and the Crown provided significant funding for community level resolution. So a good example of that is Tikaraka, where houses have both been lifted and there is a significant amount of Crown funding going into a flood mitigation to protect the community. And if neither of those things were deemed to be possible, then it's likely that they would have been assessed as Category 3. But where we've got Category 3, so, you know, Category 3 properties in the Hawke's Bay, that was where there was, lifting them would make no difference. You couldn't lift them high enough. And there was no flood bank or stop bank. And in a reasonable cost, it wasn't at any cost. I mean, presumably you can spend an extreme amount of money and build you know, big concrete structures and so forth that might protect a community, but it wasn't at any cost. It was reasonable cost.
Look, thank you most sincerely. I watched with interest from afar, and your evidence today confirms what has been a very successful, in my experience. So well done, and congratulations to you on your work. Thank you.
Yeah, good morning, Ms. Casey, and thank you for the unhurried manner you went through your evidence. It was a lot easier for me to follow anyway. I've only one question left. What was the normal process for approval of the relocation grants?
So, we went to joint ministers, which were the Minister of Finance, Minister of Crown Treaty Relationships and Minister for Cyclone Recovery to get approval to the maximum funding per residential property that we could go to, and all the bits that go into that. Also to get approval for all the extra costs. So we provided funding. So we paid for valuations, but if the owners wanted their own valuation, we paid for that as well. We paid legal fees, and where we had a complex situation where there were multiple owners and it was necessary for hui, we paid for those costs, and we paid for demolition. And in the case of the marae, we determined that marae trustees should receive an amount for administration costs, which is not usually done. So we asked ministers to approve that as well. And then we had a situation where a delegation for any individual offer to be, if it was over $5 million, would have to go to ministers. If it was under that, then I could sign it off. None of the residential whenua relocation offers were over $5 million, so I approved those within those parameters set. The marae costs, when we had all of those done, and also the extra costs we thought were appropriate, those joint ministers signed those off as well. And in terms of the total amount of funding, because the previous government had set aside $75 million on the basis that it was an initial amount and we would come back, the change of government, we asked before we knew what the costs were going to be for a contingency fund to be set up on top of the 75, and then we went back to them when we had worked out how much we needed, and they approved the total, the 136 million as well. So
so the applicant, there was no sort of application or anything, there was just that liaison between...
It was, so the individual whenua, I mean, it was, a cup of tea and lots of cups of tea and, lots of biscuits, and wider discussions, and sometimes with legal, where they wanted some legal representation. I don't think it was really a negotiation in a transactional sense. It didn't need to be. Most were, the numbers were numbers they weren't expecting. They were expecting much lower numbers, and, going back to the first questions I was asked, they were expecting that they might just get the value of the residential improvements, and we were well above that, because we wanted to get them out of harm's way, and you can't do that if they can't afford to go somewhere else.
Okay, thank you very much. Much appreciated. Those are all my questions. Thank you, Your Honour.
Thank you for your answer.
I just have a question in relation, which I'm a bit afraid to ask, given my experience in the Māori Land Court. How many of those marae were insured, and how did the insurance part of it, if they were insured?
Some of them were. We ignored it if they were or weren't. So, and that was largely because they weren't insured for very much, firstly. And secondly, some of them had started cleaning and making repairs on the basis that, by the time we got to them, on the basis that, they were expecting to have to, keep the marae where it was, and were cleaning up. So we did seek Minister's approval, but we got agreement that any insurance payments, would stay with them. but not many of them had very much in the way of insurance.
Yes, that's my experience.
Yeah, it's similar to the valuation side, as well.
Yes. So before you got to them, they would have had discussions, processes with the local government or the regional council?
Yes, so they, on the categorisation, yes, so they knew where that had got to with the council. What they didn't know is what it actually meant in terms of, what was the Crown going to do anything? Local authorities weren't. So that was kind of when we landed. And I can honestly say until we actually gave them a piece of paper with the numbers on it, we had, given them verbal offers, they didn't necessarily believe that the Crown was going to do what the Crown is doing. And there was a very moving, towards the end of our time, senior ministers and the Prime Minister were up in Gisborne, and we managed to get marae trustees from the 5 Tairāwhiti marae to come and present in their own time what their existing marae meant to them, and also what they were planning and what the future meant to them. So that was a special moment. But there were some interesting times. But I mean, their biggest, some of their biggest issues were simply, and really I don't want to oversimplify it, but were about their elders and their ties to the whenua and their memories, and how do you convince them that the future, these were decisions about the future. And I have to say that where most of them are rebuilding are very significant places to them, and some absolutely stunning sites that we hope are in safe places from whatever might come in the future.
That's very good to hear. You just said that local governments the local bodies weren't going to be doing anything for them. Was that due, do you know, to just a lack of resource to be able to do anything, or?
No, the Crown had already. Local authorities knew that the Crown was going to do something, but didn't know exactly what, and also that it was the Crown's responsibility, not theirs.
And it's the Crown's responsibility because of its te tiriti responsibilities, which the local bodies don't have. Yes, and the complexities that go with that. So I think it should always be the Crown's responsibility. And you were prepared to give that administration funding, that upfront administration funding to marae trustees. Well, from experience, they don't have the money to engage lawyers and so on, but also that they have the responsibility to do the consultation with their own beneficiary class and so on, and it all costs money to do that. Yes, the $400,000 that we gave them on signing was more for their, execution administrative costs going forward. We did give them amounts before that to help with the process. So we gave them, I think it was $10,000 for hui, just around the. We gave them $6,000 if they wanted to do their own valuation. $20,000 for legal fees and $10,000 for hui. That was all just in the process getting to the point of whether they were going to decide to move or not. If they decided not to move, it was
we weren't asking for it back, but it was to recognise that part of the process. And then we asked, recognising that the actual build and so design and so forth would take 18 months to 2 years, we asked for the 400k. Well, actually, to be fair, we asked for slightly less than that, but ministers increased it to 400k.
Well, that it would be unusual.
And might I say that was this government that did that.
Right. The present government. Thank you very much. Those are all my questions. So again, thank you very much for your evidence. I'll just hand you back to your counsel in case they have any questions.
No further examination. It remains for the Crown to thank you for your assistance in this inquiry. Thank you.
So, I think you've done wonderful work in this project, Ms. Casey, so thank you very much for your time today. We're just going to move to morning tea now, and you're most welcome to stay and have some.
Thank you.
Thank you. So we're a little late to morning tea, but because we're ahead in our timetable anyway, we will take the full 25 minutes and come back at 11:05.
just stay on mute.
Welcome back, everybody, and welcome to our new witnesses this morning. I'll just hand you over to your counsel to introduce you.
Tēnā kōrua. Welcome to the inquiry. By way of formalities, can I ask you first, Ms. Rogers, to state your full name to the tribunal?
Joanna Jenna Rachel Rogers.
Mr. Hendrickson.
Dwayne Gerard John Hendrickson.
And can I ask you to confirm that both of you have filed a joint brief of evidence for the purposes of this inquiry?
Yes.
The appellation number is A131. And can you also confirm that you have filed speaking notes for the purposes of summarising your evidence for the tribunal?
Yes, we have. Thank you.
Can I now invite you to present that summary?
Tuatahi, kei aku iti, ka aku rahi, tēnā koutou katoa. Ke tau mai te aroha, ngā manaakitanga o te atua. I ngā waka o ngā tai whā e te iwi whānui, I tai rungi te karanga o te kaupapa, kei te mihi. Tēnā koutou I o tātou tini mate, haere, haere, haere atu rā. Te hunga mate ki te hunga mate, te hunga ora ki te hunga ora. tēnā koutou katoa. Ko waiau, e mokopuna hau no muri whenua, e mahi ana hau mō te rākau whakamarumaru, e pau whakahaere mō planning and sector partnerships. Ko Dwayne Hendrickson, a hau. I'll now hand over to Jenna.
Tēnā koutou katoa, kua tai mai I tēnei rā. He mokopuna ahau no Ngāpohi, no Maniapoto hoki. Ko au te tunguaki tuarua o te rākau whakumarumaru. Ko Jenna Rogers toku ingoa. He mihi mai oha kia koutou. Thank you, Madam Chair and esteemed members of the Tribunal for having us present to you today. I'm Jenna Rogers, Deputy Chief Executive, Strategic Enablement at the National Emergency Management Agency, and I and my colleague, Dwayne Hendrickson, will provide a short summary of our brief of evidence and an update on some policy developments that have been made since the filing of our brief of evidence. We'll take turns presenting today, and we'll just start. Our written brief of evidence provides an overview of Aotearoa New Zealand's emergency management system. It explains how the system operates across the 4 Rs of risk reduction, readiness, response and recovery. It discusses the improvements that are being made to the system following recent emergencies and a number of reviews. Today we will highlight certain points in our written brief of evidence, as well as providing some detail on the Emergency Management Bill. That bill was introduced after we filed our brief of evidence last year and is currently before the Select Committee. That bill will repeal and replace the current Civil Defence Emergency Management Act. Among other matters, the bill seeks to strengthen the role of Māori in emergency management. While we understand the Tribunal will not and is unable to inquire into bills that are currently before the House, we provide this information to give fuller context to assist the Tribunal. At the outset, we want to recognise that Māori are often hit harder by emergencies, especially climate-related, like flooding, coastal inundation and severe weather. Reviews into the 2023 North Island severe weather events showed that many marae, Papakainga and Urupa, located on low-lying land, were heavily inundated. Similar impacts on Māori were seen in the severe weather events just recently at the start of this year. We also acknowledge the critical role that Māori communities and organisations play in responding to emergencies. NEMA has made progress since its establishment to develop an emergency management system that recognises and involves Māori. Over the last decade, there have been 2 key catalysts driving change across the emergency management sector. The first was the 2017 ministerial review into the Port Hills fires and the Kaikoura earthquake responses. The second was the government inquiry into the 2023 North Island severe weather events. These reviews recognised the important and unique role Māori have in emergency management and made recommendations to recognise and strengthen the role of Māori. This has resulted in numerous improvements to the system. Some of these include the inclusion of a formal Māori-focused function in the Coordinated Incident Management System, a system used in response to provide a critical connection to Māori during emergency responses. The inclusion of a specific objective in the current National Civil Defence Emergency Management Strategy to incorporate greater recognition, understanding and integration of Māori perspectives and tikanga in emergency management, as well as NEMA having developed a 10-year Māori strategy, Te Kāhui Matara, for our agency to connect with Te Ao Māori. While these improvements are a promising step forward, we'd like to acknowledge there is still a lot more to do. New Zealand's emergency management system is devolved. This means responsibility is shared. Local councils, emergency services, Māori, health providers, government agencies, lifeline utilities, the private sector, and community groups all play a role, alongside NEMA, who as steward of the system leads and supports the system. The system is underpinned by the idea that emergency management is locally delivered by communities and local authorities, regionally planned and coordinated through emergency management groups, and nationally supported by central government. This devolved structure recognises that most emergencies in New Zealand occur on a local or regional scale and are therefore best managed locally in the first instance by local authorities. They know, for example, which parts of the river are likely to flood, which parts of their communities and infrastructure are most at risk, what capabilities and resources are on the ground, and where assistance will be needed. Local authorities are the key touchpoint between local level Māori organisations and the emergency management system. Locally led emergency management is a strength of the system, but there are also downsides to this approach. We acknowledge that the delivery of emergency management is variable in practice across the country. This is based on the uniqueness of regional and district capabilities, resourcing, communities themselves, and the hazards they face. And system improvements can be slow to roll out and implement in a devolved system. At the local, regional and national level, different emergency management organisations have different responsibilities. At the local level, all local authorities are required to plan and provide for emergency management in their districts. As part of this, local authorities have systems in place to establish and operate emergency operations centres during response and to ensure they are able to function to the fullest possible extent during and after an emergency. At the regional level, every region is required to have a Civil Defence Emergency Management Group. These are known as CDEM groups, colloquially. We'll be referring to them that way. There are 16 CDEM groups across New Zealand. These groups are formed by the councils in a region. This can include district, city and regional councils, represented ordinarily by the mayors of those councils. Each CDEM group is supported by a coordinating executive group, known as the KEG. The KEG includes the chief executives of the local authorities and senior representatives from Police, Fire and Emergency New Zealand, the chief executive or a senior member of a provider of health and disability services operating in the area. The KEG provides advice to the CDEM group and oversees the implementation of the decisions of the CDEM group. Māori participate and contribute across the emergency management system. The most recent data held by NEMA shows that Māori are represented on 10 of the 16 CDEM groups and on 14 of the 16 KEGs. Once the Emergency Management Bill is enacted, Māori representation and participation will be a mandatory requirement. While NEMA has oversight of the CDEM system and some influence over CDEM groups, the system is inherently devolved. This means CDEM groups operate independently of NEMA and central government. The 16 CDEM groups are not managed by NEMA. However, if a state of national emergency or a national transition period are declared, the CDEM Act prohibits local and regional powers being used contrary to any priorities set by the Director, National Controller or National Recovery Manager who are NEMA employees. At the national level, NEMA is the central government steward of New Zealand's emergency management system. NEMA was established in December 2019 to replace the Ministry of Civil Defence and Emergency Management. It has grown from a small agency of around 60 staff to 173 staff as at June 2025. Despite this growth, NEMA remains a small organisation and relies heavily on surge capacity during emergency responses and recovery. NEMA has leadership, policy and advisory roles, but its core operational role is managing the central government's response to and recovery from emergencies. As we will discuss later, NEMA's role in an emergency varies depending on the size of the emergency, whether a state of emergency has been declared, and whether it is a national or local state of emergency. In most emergencies, NEMA is in a supporting role, with CDM groups or local authorities leading the response in their regions or districts. NEMA does not have any statutory powers or functions. Rather, NEMA supports the national statutory officers, namely the Director of Civil Defence Emergency Management, the National Controller and the National Recovery Manager, to carry out their functions under the Civil Defence Emergency Management Act. Since NEMA was established, there has been a strong focus during business as usual activities on working with Māori communities. More recently, NEMA has created roles dedicated to support engagement with Māori and to help build an emergency management system that recognises and includes Māori. These roles are discussed in our written brief of evidence at paragraphs 73 and 74. NEMA's executive has also recently agreed to Te Kāhui Matara, a 10-year strategy with a goal to develop a culturally capable agency over the next decade that is connected to Te Ao Māori through practice and meaningful engagement. There is much work to do to build this capability, and Te Kāhui Matara sets out the path for this journey. In emergency response, NEMA has a dedicated function, tā kai here, that provides support and coordination for response efforts involving Māori communities across Aotearoa, New Zealand. During response, that function collaborates with CDM groups, local and group controllers, Māori and community groups to do two things: identify the needs of Māori and coordinate the delivery of strategic Māori-specific advice. We note while our evidence focuses on core emergency management agencies, emergency management is not carried out by a single agency. It is a broad concept and a shared responsibility that requires a whole-of-society approach. Alongside NEMA, CDM groups and local authorities, there are a multitude of agencies with specific roles in emergency management. This is discussed further in our written brief of evidence at paragraphs 77 to 86. There are several legislative and planning instruments that together form the framework for New Zealand's emergency management system. The key instruments are listed on the PowerPoint. The Civil Defence Emergency Management Act, or CDM Act, is the foundational legislation, establishing the framework for emergency management in New Zealand. It aims to manage hazards sustainably, to support public safety and well-being, protect property, and help communities manage risk at acceptable levels. The CDM Act takes an end-to-end approach managing risk. It requires a number of entities to identify, assess, and manage hazards and risks, and to carry out readiness activities. It also provides statutory role holders with powers that can be used during declared states of emergency and during recovery and transition periods. The CDM Act does not mandate Māori participation. This is changing under the new Emergency Management Bill, which I will discuss later. The National Disaster Resilience Strategy is the Crown's National Emergency Management Strategy required by the CDM Act. It is a 10-year strategy covering 2019 to 2029. Its purpose is to outline the vision, values, principles and goals for emergency management in Aotearoa, New Zealand. The strategy sets out 18 objectives. One of those objectives is incorporating greater recognition, understanding and integration of Māori perspectives and tikanga in emergency management. The National Civil Defence Emergency Management Plan and Guide identifies the hazards and risks to be managed at the national level. It also sets out the roles and responsibilities of agencies involved in reducing risks and preparing for, responding to and recovering from emergencies. The plan recognises the needs communities, including iwi, hapu and whānau, may have during an emergency. Te Puni Kokore has specific responsibilities under the plan to work with government agencies and CDM groups to support iwi, hapu, whānau and other Māori communities. Each of New Zealand's CDM groups, 16 CDM groups, must have their own CDM group plan. The plan sets out the hazards and risks the group will manage in its region and the arrangements for delivering emergency management. Group plans must take into account the Director's guidelines issued under the CDM Act and must be consistent with the National Disaster Resilience Strategy. At present, there is currently no explicit requirement under the CDM Act for groups to engage with Māori on the development of their group plans. This will change with the Emergency Management Bill. In the future, CDM groups, who will be called Emergency Management Committees, will be required to engage with and involve representatives of Māori in the development of their CDM group plan. Lastly, in the legislative framework, the Director of Civil Defence Emergency Management is empowered to issue guidelines under the CDM Act. There are currently 19 active Director's guidelines covering different areas of emergency management. The Director's guidelines are flexible, living documents. They can be updated to reflect changing circumstances, including lessons or new arrangements. As a result, they are the part of the CDM legislative and planning framework that has most comprehensively addressed Māori engagement to date. Guidance on building effective connection with Māori is included in many of the Director's guidelines, including guidance on welfare services, CDM group planning, risk assessment, and recovery. These guidelines are discussed in our written brief of evidence at paragraph 58.
I'll now speak to the 4 Rs. In emergency management, we refer to the 4 Rs. The 4 Rs capture the end-to-end approach to managing the risk of hazards, with action required across risk reduction, readiness, response, and recovery. Risk reduction involves identifying and analysing risks and then taking steps to eliminate or minimise their likelihood or consequences. Readiness is about preparing people, communities, agencies, and developing capabilities to respond effectively when an emergency happens. Response covers those actions taken immediately before, during, or directly after an emergency to save lives, protect property, and support communities. Recovery is the coordinated efforts and processes to regenerate and enhance communities after an emergency. I will now outline in more detail each of the 4 Rs. On risk reduction, NEMA's role is to provide advice and enable others across the system to take action. NEMA's role as a steward of the system is to advocate for risk reduction as part of holistic emergency management. Operationally, much of the work to reduce risk from natural hazards sits outside the emergency management system. It is carried out by other agencies under different legislation, particularly the Local Government Act, the Resource Management Act, the Building Act, and the Climate Change Response Act. NEMA and its statutory officers do not have powers or responsibilities under these regimes. Under the CDM Act, CDM groups are required to identify, assess and manage hazards and risks in their regions, to communicate about those risks and identify and implement cost-effective ways to reduce risk. In relation to climate change specifically, climate change is changing New Zealand's riskscape. Climate-related emergencies are happening more often and are becoming more severe. The emergency management system's core operational role is to respond to and support recovery from those events. While NEMA and other CDM organisations contribute to reducing the impact of climate change, this work is largely led by other agencies through different statutory frameworks outside the CDM Act regime. Some examples of NEMA's recent work on risk reduction matters in relation to climate change issues are discussed in our written brief of evidence at paragraphs 98 to 111. Readiness is about developing operational systems and capabilities before an emergency happens. On readiness, NEMA focuses on building a connected, capable, and prepared emergency management system. This approach supports individuals, communities, and agencies to take part in managing the impact of emergencies. NEMA strengthens national and local readiness by supporting CDM groups and partners. Some of NEMA's key readiness activities that are focused on enabling and facilitating connection and engagement with Māori are discussed in our written brief of evidence at paragraphs 115 to 131. Response includes those actions taken immediately before, during, or directly after an emergency to save lives and protect property. An emergency in the CDM context is not the same as what many people might refer to as an emergency, such as a traffic accident or a fire. In the CDM context, emergency is defined under the CDM Act. A situation must meet 3 criteria to qualify as an emergency under the CDM Act. It can be caused by any hazard, natural or human-made. It causes or may cause loss of life or injury to people, or loss of or damage to property, and it is serious enough that it requires a significant and coordinated response under the CDM Act, for example, because it cannot be dealt with by emergency services. This means the CDM response framework only comes into operation where hazards and risks become, or look to become, emergencies requiring a response at a level that cannot be dealt with by emergency services under their usual statutory frameworks. NEMA's role in response varies depending on the nature of the emergency, whether a state of emergency has been declared, and if one has, whether it is local or national. When a non-declared local emergency event has occurred, NEMA may support the response, for example, by issuing warnings, providing monitoring, reporting, and situational awareness. When one or more local states of emergency have been declared, operational control remains with the relevant local or regional controllers. However, NEMA can provide support and assists CDM groups as needed with coordination, guidance, and resources. When a national state of emergency has been declared, NEMA directs the national response through the National Crisis Management Centre, supporting the Director of Civil Defence Emergency Management and the National Controller, who assume overall control of the response. In New Zealand's history, there have only been 3 national states of emergency declared. Most of the emergencies declared in New Zealand under the CDM Act are at the local level, managed by CDM groups or local authorities. Coordination centres. In response to an event, a number of different coordination centres may be activated to manage the response. At the local level, an emergency operations centre is activated by local authorities when a local incident escalates beyond routine response. They manage the local CDM response and coordinate agencies within the district. For example, an emergency operations centre is activated to manage the response to a local flood in a district. At a regional level, group emergency coordination centres are activated for regional emergencies affecting multiple districts. They coordinate the regional response, support the group controller, and bring key sectors including emergency services, social, and infrastructure together. For example, a CDM group may set up a group emergency coordination centre to respond to a widespread severe weather event that affects multiple districts within a region. At a national level, NEMA's National Coordination Centre or National Crisis Management Centre are activated for events requiring national coordination. They are led by NEMA, but work with regional group emergency coordination centres and provide the main link between CDM groups, agencies, and ministers. For example, when a national state of emergency was declared following the 2023 North Island severe weather events, including Cyclone Gabrielle, NEMA activated the National Crisis Management Centre, which operated out of the bunker in the Beehive to coordinate the response. The operation of these coordination centres reflects that the emergency management system is not the work of any one agency. Detail about these different coordination centres is discussed in a written brief of evidence at paragraph 137. Coordinated incident management system. Given an emergency brings together so many sectors and agencies, a common language and framework is required to make it work. This framework is called the Coordinated Incident Management System, generally known as SIMS. SIMS has been designed for the New Zealand context to achieve effective coordination across all responding agencies. SIMS is a scalable framework designed to operate at any level of response, from individual incidents through to local, regional, and national emergencies. It provides common structures, functions, terminology, and processes so that people and agencies can work together effectively during emergencies of any size. SIMS also includes a set of functions that can be activated depending on the size and needs of an event. These functions cover areas like intelligence, planning, logistics, welfare, and public information. The current version of SIMS includes a specific Māori-focused function. At the national level, NEMA has built on this function to more effectively engage with Māori during an emergency response. This has resulted in NEMA reframing the SIMS function as tākahiri. That function provides support and coordination for response efforts involving Māori communities across Aotearoa, New Zealand. Further detail about this function and its development are discussed in a written brief of evidence at paragraphs 145 to 152. Recovery. The final R is recovery. Recovery involves coordinated efforts to support immediate, medium-term, and long-term holistic regeneration and enhancement of a community following an emergency. Recovery can take weeks or months, and in some cases years or even decades depending on the scale of the impacts. Recovery begins as early as possible during the response phase and continues well after an emergency has passed. Planning for recovery alongside the response helps to ensure that immediate response actions support long-term resilience and reduce future risk. For local recoveries, local authorities and seeding groups are responsible for managing and carrying out the recovery effort. The Director's Guidelines issued by NEMA make explicit the need for seeding groups to build relationships, collaborate, and engage with Māori. NEMA may also work with Te Puni Kōkiri to ensure seeding groups and local authorities are appropriately supported. For larger recoveries requiring a nationally coordinated effort, NEMA is the responsible agency. For example, this year, following the severe weather events at the start of 2026, NEMA established a National Recovery Office to lead and coordinate the central government recovery efforts. The National Recovery Office continues to engage and connect with Māori as part of their recovery work. For certain nationally significant and complex recoveries, a new agency or entity may be set up to manage and coordinate recovery activities. For example, in 2023, the Cyclone Recovery Unit, hosted by the Department of the Prime Minister and Cabinet, was established to oversee recovery activities following the Auckland floods and Cyclone Gabrielle. In that situation, the new agency facilitates connection and engagement on behalf of the Crown with Māori.
Before speaking to the last part of our evidence system improvements, we wanted to comment on one of the key concerns claimants have raised: how the emergency management system is funded. We acknowledge funding of the emergency management system is an ongoing challenge, especially due to the increasing frequency and severity of weather events resulting from climate change. The emergency management system is primarily funded at the local level. CDM groups all have slightly different funding models, but for all of them, their funding is based on the local rates system. They are not funded by central government. Like many aspects of local government, the needs of communities are not always proportionate to their rating base. Some additional funding is available from central government to support emergency management work. For example, the CDM Resilience Fund is a fund administered by NEMA for the benefit of local and regional initiatives to manage risk, build CDM capability and capacity, and to enhance community resilience. Organisations and communities can apply each year to get funding via this fund for specific projects. One of the relevant criteria is whether the project will achieve equitable outcomes for Māori, marae, hapu, iwi and Māori organisations. Details on some of the projects this fund has funded are discussed in our written brief of evidence at paragraph 117. We acknowledge that during response and recovery, marae often act as de facto civil defence centres and provide critical welfare and community support. The government meets 100% of eligible costs incurred by local authorities for providing welfare in an emergency as per their responsibility to do so. Increasingly, iwi and hapu are opening marae and other facilities to support and provide manaakitanga to affected communities. As a result, local authorities can pay iwi and other organisations to provide this welfare support. Or local authorities can provide koha to marae and then be reimbursed. However, this process is not standardised across the emergency management system, and more work is needed to improve these funding arrangements. In the government's recently adopted roadmap to strengthen emergency management in response to the government inquiry into the North Island severe weather events, the government has acknowledged that the emergency management system is under-resourced and needs vary across the country. Some of the most at-risk regions have the least resourcing, and local government needs more investment to deliver emergency management at the standard that New Zealand deserves. The roadmap commits the government to developing options to improve funding for emergency management at the local and regional level. This is one of several commitments the government has made by the roadmap. Other key commitments include developing public readiness programs to help the public better prepare for emergencies, expanding the Resilience Fund to support communities to build local resilience and capability and capacity for response and recovery, professionalising and building the capacity and capability of the emergency management workforce, and modernising emergency management technology to support faster decision-making and to ensure local, regional and national agencies are all working from the same information during emergencies. The commitments in the roadmap acknowledge that the emergency management system needs strengthening, and they mark an important starting point for further reform. However, delivering on these commitments will require significant policy work, legislative change and sustained investment. It is therefore a work in progress. Turning now to the final part of our written brief of evidence on system improvements. As we noted at the outset, there have been a number of improvements to the system in recent years, but more work is still needed. One of the most recent improvements that is not discussed in our written brief of evidence is the Emergency Management Bill. The bill was introduced in December last year after our brief of evidence was filed. The Emergency Management Bill will repeal and replace the CEDM Act. The bill is currently before Select Committee and is expected to come into force this year. A key focus of the changes in the bill is to strengthen the role of Māori in emergency management. There are a number of ways the bill seeks to achieve this. Firstly, there is a requirement to appoint one or more members to the coordinating executive group. The KEG at the regional level, with the knowledge and of interests and values of local Māori communities. Secondly, CEDM groups, to be known as emergency management committees, will be required to engage with and involve representatives of Māori in the development of their emergency management plans. And thirdly, the Director General of Emergency Management, who is replacing the role of the Director of Civil Defence Emergency Management, will be required to engage with and seek advice from representatives of Māori in the development of the National Emergency Management Plan. The bill also makes changes to better support people who may be disproportionately affected by emergencies, which may include Māori. These changes include requirements that disproportionately affected communities are identified. There is engagement with representatives of those communities when developing the national and regional emergency management plans. And at the regional level, emergency management plans must set out the arrangements for the needs of those communities. We emphasise that while the bill is intended to strengthen the role of Māori in emergency management, NEMA and the emergency management system are not waiting for the bill to be enacted. There are many improvements that have already been made, and implemented or are underway. These are discussed in our written brief of evidence in paragraphs 164 to 204. That concludes our summary of our brief of evidence. Dwayne and I are now available to take any questions.
Thank you. The first questions are from Sykes & Co, Mr. Fletcher.
Tēnā kōrua, ko Fletcher tōku ingoa. Before I get into my cross, I thought I'd just give you a note, Mum. I think in all that back and forward about this afternoon, I probably didn't inform you that I'll try and take half an hour rather than 50 minutes to free up some time for this afternoon. I wanted to start by acknowledging, I think it's throughout all your evidence really, but particularly the sentiment you've expressed at paragraph 7 of your speaking notes, where you said, look, it's a promising step forward, but we acknowledge there's still a lot more to do. I think it's nice to hear the Crown come to the tribunal and be sort of upfront about that kind of narrative. I thought we could start with Te Kahui Mātara. I'm hoping you have a copy of that in front of you somewhere.
We may.
I do.
Oh, fantastic.
So just as we open it up, it might just be the version that I've got in front of me, but out of curiosity, there's a draft watermark on it. Is there a final version, or are you still working on it?
There is.
So yes, it's been endorsed, but like any strategy, it does go through review as we, and to our speaking notes, there is improvement as well.
Can I take you to the top of page 4 of the document? You have that?
Same.
So when I look here at where we're aiming to go, we say build and sustain meaningful relationships with iwi Māori across government at local, regional and national levels. So I think while your brief of evidence talks a lot about the importance of localism, I think it's clear here that you do see NEMA as having a role in having relationships itself. It's not just about local councils and other government agencies having those relationships. You'd agree with that?
Correct.
Yeah, you probably already know this, but just for the record, it's helpful to have a yes or a correct. It's very natural to nod, but it's quite important for the lawyers in the tribunal. And I guess it's sort of implicit in that, but if you're going to have the relationships, or later on in the document talking about allowing for effective engagement and input into advice, you have to speak to people yourselves. You can't always rely on other people to do that for you.
Correct.
So I guess where I'm going to drive at with my questions today, thinking about, I think you used the term of NEMA being the assurer of the system, is what exactly it looks like for you to have the relationships and knowledge to be able to satisfy yourselves that other people, as well as the Crown itself, is doing that and has those relationships and is acting in that assurer role. As well as, and I'm only going to touch on it because I'm conscious my friends from the Crown want me to talk about the bill too much, but as you talked about at the end of your speaking notes there, as I understand it, the new legislation has quite specific requirements in that regard too.
Yes.
So can I take you first of all to paragraph 42 of your brief?
Just to be clear, the brief of evidence or the summary?
The brief of evidence. So I understand the argument that says that localism is good when you're dealing with local knowledge and local disasters which have local impacts. But obviously, depending on the scale of the disaster, we might have local impacts amplified across a wider region. And one of the concerns I think we have when we're talking specifically about climate change related impacts like Cyclone Gabriel, as those tend to often impact quite a larger area. So it seems to me as a starting point that localism, as you're talking about here, doesn't exclude a role for a coordinating agency. Is that a fair statement?
Correct.
And in order to ensure that different parts of the local network are operating effectively, there has to be someone who, you use the word assurer, I might use the word steward a few times, is overlooking that process.
Correct.
And that process exists, again, as a starting point. It might be more critical and more time sensitive during the disaster, but the role exists when things are hopefully slightly more normal, whatever that looks like in the current era.
Yes.
So when you say at paragraph 43 that you're not losing sight of the Crown's role as Te Tiriti partner, I'm just curious as to what exactly you mean by that in the circumstance that we're agreeing, I think, that there's quite a lot of stewardship and assurance to do even when there's not a disaster. Can you just talk me through what you mean by that? It sort of seems like you're delegating that role a little bit to local authorities.
Certainly, NEMA, first and foremost, I think it's important to acknowledge we, as the Crown, have our own treaty obligations, and certainly the way we operate is to honour those obligations. We meet with iwi, we prioritise those meetings, and an example of that would be meeting with the NICF, the National Iwi Chairs Forum, and the development of various products, including the Emergency Management Bill. In terms of the local government and the localism you were referring to in the brief of our evidence in 42 and 43 paras, the role we play is, I would suggest, in addition to what we would expect is also occurring at the local government level, and particularly as we've outlined, where was it, in para 43, around runanga, iwi, hapu, marae, those very much local, particularly with hapu and marae, relationships are expected to be carried out at that local level. But certainly NEMA will be having relationships as well as those. So it's not an and or, in this instance it's an and.
And I guess to foreshadow where we might go a little bit later, without wanting to draw you into, like the last witness didn't want to be drawn into criticisms of local government. Some local councils may have less funding than others, and some local councils may be less, shall I say, good-spirited than the people I'm currently talking to. That means sometimes you might need to step in if you don't think a local council has that kind of knowledge at a local level?
I wouldn't say step in. I would use the word encourage and influence words. NEMA certainly is a highly operational agency alongside policy. And where we are developing policy, the legislative and regulatory environment I discussed earlier, which includes directors' guidelines, we issue those guidelines to local government. They need to take account of them. They really are to support and enable them to carry forward a number of functions, including engagement with Māori. And we work very hard on implementation of those guidelines alongside what sits in our regulatory environment more broadly. NEMA has a small regional partnerships unit. Those staff are actively in the local government arena as a day-to-day part of their job. So they're not in the national headquarters of NEMA, they operate out in the regions and they work alongside local government to actively monitor, understand, encourage and influence and support fundamentally the carrying out of those responsibilities that are in directors' guidelines. We also hold a number of hui across either at regional or national levels with the Civil Defence Emergency Management groups and with those statutory office holders, group controllers, recovery managers, where again we'll be encouraging those relationships to be established. And at times we'll bring both parties together. We've carried out a number of wānanga and hui that actually bring iwi and setting groups together as well.
was going to come to this later, but can I take you to paragraph 63 of your brief of evidence? So if I understand what you were just saying, in answer to my previous question, there's quite a lot of work, and it does sound like a small unit you said, but the regional partnerships level going around supporting particular CDM groups. So I'm just curious about the example you've given at paragraph 63. Is that exactly what you just talked about?
It's an example. Yes, do you want to talk to this one, Dwayne?
Yeah, I can. The CDM group plans are owned by the CDM group at the local government level. However, we can be requested to provide support. And in this case, we provided support with an understanding of relationships, an understanding from the technical review process of those group plans. But we didn't impose ourselves on the group. It was at their request. And so there's an aspect of being tika throughout this process. So I would say this would be an example of us being complementary to the system, and ultimately the result was an enhancement of those relationships, so a mana enhancing approach.
Right. So you've already said it, but just to break that down, I was going to put this before in a different way, but for you, being requested to do this is critical. You're not trying to go for a stick approach. This is a kind of carrot, complementary, to use your word, relationship.
Yeah, I think I come back to the mana enhancing aspect of it. It would not be for us to use a stick approach in the relationship space with iwi Māori. But we certainly have those conversations with the CDM group, and those sort of conversations can be robust, but that's an appropriate part of how we work together as a working relationship.
This is all sounding very good, but then I'm a bit stumped by the last sentence of paragraph 63, because both in terms of this specific example and what you're telling us that these are an example among several, but you're also saying in the brief quote that you've got limited capacity to adopt this as a standard practice. Now, can you help me thread the needle there?
Yeah, so we have 173 staff as of June 2025, and we have a small but dedicated number of Māori SMEs. At the same time, there are 16 CDM groups with their own varying degrees of resourcing. Some of them have a more deep relationship with those that hold mana whenua within their regions. Others are earlier on that journey. And so the way in which we support can vary quite significantly, depending on the need, availability of staff, and the request.
So I'm conscious I'm talking to a small Crown agency with limited budget, but as you've said, you've expanded quite rapidly in a relatively short period of time. Is building that capacity internally a priority for you?
So that is part of the intent of Te Kāhui Mātara, and that is something that we will need to journey on over time.
If I can just add to that, though, I would suggest that it has been a priority. Certainly the Māori capability and the staff and the subject matter experts that we have in the agency now, we did not have in the agency prior to NEMA being stood up when it was 60 to 70 odd and was the Ministry of Civil Defence Emergency Management. So it really has been a priority.
I'll jump back to where I was in my notes, and I want to talk a little bit now about the resourcing issues that you've touched on in your speaking notes. So can I take you to paragraph 51? So obviously the CDM groups, as I understand it, are deliberately imposed over existing territorial boundaries. If we have localism, we may as well use the existing local legal structures and communities that are there. Is that a fair summary?
They do marry with regional council boundaries generally, or unitaries of that nature.
And in addition to the broad proposition at the first sentence of paragraph 51 that needs are not proportionate to rating base, obviously we're not defining CDM groups then based on what you might think of as a proportionality assessment of places that are more likely to be affected by disasters or climate change. We're just using the existing regions that we have.
Correct.
So it's implicit in that, but then when we decide how different CDM groups operate at place, we're not doing any kind of assessment as the Crown or as NEMA as to what the capacity of that particular CDM group or the resourcing for that CDM group is for responding to a disaster.
No, that's determined by them at that regional and local level.
And I don't want to stray too much into the current bill, but my understanding is that's a pretty established part of the system that's not going to change.
Correct.
I wanted just to touch on, in paragraph 52, there's a slight difference, possibly I'm reading too much into it, between your speaking notes and your brief here. That last sentence, NEMA has commenced discussions with DIA to develop options, equitable funding of emergency management requirements. Are those discussions ongoing?
They've really only just begun.
Okay, your brief was October last year. It's a long process for you to get this done.
The key thing for us is both agencies have big legislative reform programs, the local government system improvements and the emergency management bill, and we really need those sets of legislation and change to be carried forward. But this work it has commenced. There's a lot in the roadmap that has commenced in terms of the scoping and the development of the necessary policy work that needs to be carried out.
So let's just break that down. I understand capacity issues within government departments, but I don't understand these legislative changes to be required before you can start making conversations about funding changes. You're not saying that, are you?
No, I'm saying it's being done concurrently.
Cool. Okay. And just to give you a fair opportunity to respond, I was a bit surprised these discussions weren't mentioned in your speaking notes. From what you're saying to me now, these are quite an important part of your prioritising, addressing funding inequities. Is that a fair inference?
I would say that every aspect of the roadmap is important.
Okay. And just finally, I wanted to talk a little bit about NEMA's capacity, and particularly the capacity of an agency which has, I really liked the phrase you used in your speaking notes, surge capacity. Obviously you're going to expand on a disaster. I don't have the knowledge of the bunker that I suspect you two do, but my understanding is it's quite an intense place to work when the bunker gets deployed. When you're bringing a whole bunch of people into an organisation, I assume they're seconded, to work during a disaster, presumably you're bringing in people from a range of different agencies within government and potentially local knowledge too. Is that a fair assumption?
Correct.
And obviously, even if you've established a really strong internal structure for how you engage with iwi Māori as an organisation, if you're bringing in a whole bunch of new people from outside the organisation, they're not going to have necessarily that knowledge. And they're also going to have to be doing this and upskilling potentially at a lot of speed and under a lot of pressure. So I was just curious as to how you see that particular dynamic playing out.
I think you touch on a very important point, which is why the tākai here function is so important to be established as part of the SIM structure that we presented earlier. So in terms of that National Crisis Management Centre response, we surge people from all over the system, particularly the public service, for things like planning, logistics, operations, public information, welfare, and tākai here. And that's where we absolutely can draw people with those specialist skills from Te Puni Kōkiri, for example, to actually bolster that function, and that is what is done.
Thank you, that's helpful, but I think I might be asking a slightly different question. Even if you've got people coming in from Te Puni Kōkiri who have that knowledge base and that skill set, they're coming into a new organisation under pressure and at speed. So I'm trying to understand how they jump into the fire and share that knowledge around, if that's the way you want to put it.
Do you want to talk to this? I can see
you. Sure. Tākai here is a relatively new capability that's been set up, and I think it's important to recognise that when we talk about the evolution of the iwi liaison role under SIMS 3, Tākai here recognises the broader depth of capability that is engagement, is strategic advice, up, down and across. We've developed a Tākai here standard operating procedure that includes a task list that allows for rapid orientation of those staff who are seconded and deployed into the bunker. Like in any emergency response, and particularly one at the scale where the bunker is required to be activated, there is an element of chaos. But those tools are intended to rapidly bring people together so they can be effective.
And just to touch on some of what you were saying to me earlier, maybe this is an unfair, simple way of putting it, but that's particularly hard if you're trying to upskill people on matters of tikanga, which might take time to get their heads around it, even in a non-disaster context. Do you find that, or do you think you'll find that, given it's new?
I will acknowledge that, but at the same time, there is a strong network of Māori public servants and those across the emergency management system, and this is the work we do in readiness as well. I would also say that those, from what I've seen, who deploy into the tākāhere function, leaning into those values of manaakitanga and whakawhanaungatanga are able to rapidly connect and be effective.
Okay. I'm leaping around a bit, sorry, because I'm trying to respond to your very helpful answers. But the final thing I wanted to talk about under this topic was really just about what you were talking about in your speaking notes at 57 around the way that marae, I think you used the word reimbursed for costs incurred during disasters. Do you have that handy?
Yes.
Fantastic. So first, just really a clarification. The sentence, or local authorities can provide koha to marae and then be reimbursed. Are you saying reimbursed from the Crown? I didn't take your evidence to be saying that.
Can you just double check which paragraph you're looking at?
57 of the speaking notes, page 10.
Oh,
Apologies, it wouldn't be the first time I've thought one number and said one other one out loud.
So please repeat the question.
So there's a sentence there, all local authorities can provide koha to marae and then be reimbursed. And I'm just looking to clarify, are you saying reimbursed by the Crown? Because that wasn't...
Correct.
Oh, okay. So you said elsewhere in your evidence that there's limited Crown funding to do things like that. So is the pool quite small, recognising the kinds of costs that might be incurred during a disaster like Cyclone Gabriel?
In para 56, we've outlined the government meets 100% of eligible costs incurred by local authorities for providing welfare in an emergency as per their responsibility to do so. So under current arrangements, local authorities, SEDM groups are responsible for sheltering, feeding, supporting displaced people, affected communities. The government has a permanent legislative authority whereby we reimburse those local authorities for 100% of the costs they incur. There's eligibility criteria around it.
Sure.
And the current arrangements are that those local authorities can in turn, or rather iwi Māori can work through those local authorities to be reimbursed. So any manaakitanga, any welfare support they provide to communities, they can in fact be reimbursed through the local authority, permanent legislative authority through to the Crown.
And does that permanent legislative authority then require iwi Māori, local authority, Crown? You can't go over the top?
Correct. It's not ideal, which is why I highlighted that in my summary of the brief of evidence. So it's something that we are looking into. Koha can be a far more straightforward process. We are really mindful of the clunkiness of that, and it's somewhat bureaucratic. So it's another one of those areas that we're looking into. In the most recent event earlier this year, we really wanted to fast track that process, and it was a high trust model whereby we sought $1 million to be expended by Te Poni Kōkiri really rapidly through their marae development fund. On the basis that we're seeing this more and more, we're all aware of the role that marae are playing. We want to really make it as seamless as possible for them. That was a workaround. We need to actually develop the more permanent policy process to support that.
So this might be a hard question to answer directly, but it sounds like from that summary it would be a lot easier if you just worked with Te Poni Kōkiri to pay marae directly rather than going through local authorities.
It may be the outcome, but we have to do the policy work.
Okay. Can I then finally talk to you a bit more about engagement? And I wanted really, and this is a nice segue, to talk about the relationship between NEMA and Te Puni Kōkiri in this space, because it may be obvious, but I'm struggling to understand it. So can I take you first to paragraph 33 of the brief of evidence? So I'm just curious about this last sentence. The plan assigns Te Puni Kōkiri responsibility for working with other government agencies and CDM groups to support iwi, hapu, whānau and other Māori communities. Given what we've been talking about, particularly with that example from Taranaki, that seems to me to be an oversimplification of what NEMA is doing, based on your evidence today.
I'll talk to this one. That's derived from the current National Civil Defence Emergency Management Plan. Those arrangements are now 10, 11 years old. So it's fair to say that they are a reflection of their time. We have really advanced since that. It's not to say that Te Puni Kōkiri does not have an excellent network, particularly with its regional offices, in a way that NEMA does not. So we do work really closely with them. But NEMA has, as we've talked about previously, actually developed and advanced our own capability, our own scale, dare I say it, though it's still rather small, and certainly the expectation that local government is also advancing those relationships into the regions themselves. So in this instance, this is talking about welfare arrangements, and we do still work very closely with Te Puni Kōkiri, particularly at that national level.
So I was going to ask you some questions about that welfare plan, but in light of that evidence, I think I might just put this to you. You'd agree with me if I said that when you are able to update that plan, it being 10, 11 years old, it probably won't look the same way it does about your role as compared to Te Puni Kōkiri's role. Is that a fair assumption?
I don't want to get ahead of the actual policy work to develop it, but I would certainly say the plan will be a different plan and it will reflect new arrangements that have advanced in the last 10, 11 years.
Maybe just in my last couple of minutes we can talk a bit more specifically about that then, if we can go to that welfare plan. I'm hoping you have a copy of. It's one of the appendices to your brief.
Can you list which document that is, please?
I have the Crown's numbers. It's NEMA.001.1034. I'm not sure if your one will have the Crown's numbers as well.
The title of it, please?
Oh, sorry, the title. Too much of a lawyer mode. Welfare Services in an Emergency Director's Guideline for CDM Groups and Agencies with Responsibilities for Welfare Services in an Emergency.
Great, Director's Guideline. So we don't have that, I don't believe.
That's okay, I'll put that question in writing.
We can bring it up if that's helpful.
Oh, I'm conscious of time as well. I'm in Your Honour's hands.
We've got the time.
Okay. In that case, I'd be very grateful if you could. Thank you. Outstanding. Can I go to page 82 of the document, please? I don't know if this will help whoever's running the drive, but on my Adobe it says 90 on the right-hand page numbering. Oh, I see you got a combined bundle. Sorry, that wasn't helpful. If we just look there, you can see in the middle, maybe we could blow it up a bit on the big screen. Te Puni Kōkiri to work with other government agencies and CDM groups to facilitate and coordinate support to Māori who require assistance. That, in this document, sounds a lot like what you're saying NEMA does now. Hence my surprise that you're not willing to agree with me that this document seems kind of out of date in this day and time.
This document is also from 2015. The way it's written, it's quite interesting to reread that now. The way it's written also makes it sound as though it's specifically Te Puni Kokiri that does the primary engagement and or coordinates support to Māori. I would suggest that is very much a CDM group and a NEMA responsibility. I'm not sure that was ever the intent of that language, to be honest with you. In terms of welfare is a function under SIMS. It is a really broad, large function with a number of sub-functions, dare I say it. This is all sounding very technical, apologies. Whether it's providing shelter, accommodation, household goods and services, it could be care for children, care for animals, financial assistance, psychosocial support. It is the largest function that comprises around 60 different agencies that come together to provide wraparound support to affected community members. Really, certainly there are a number of different agencies that are either service delivery, core service delivery agencies, and then other agencies that are more advisory, that are more population-based, so Office for Seniors, Ministry for Pacific Peoples, Te Puni Kokiri, and that's certainly the way in which, especially in 2015, Te Puni Kokiri was seen by NEMA, or McDem, our predecessor, as the key agency for providing advice on Māori matters, particularly as the Crown's Māori Affairs Agency. And I think that is still very much appropriate, but it's about advice that then gets interwoven across all of those service delivery agencies.
I think we're probably on the same page, but just to pick up on something you said in that answer earlier, I think you said that the way that reads now probably wasn't ever the way it was intended to read. Is that a fair summary of what you said? That NEMA and CDM groups are really who facilitate and coordinate support to Māori. It's not just Te Puni Kokiri.
Absolutely.
Yeah. And I think I'll just do one more question. Can I scroll down to page 115 of the same document, please? Actually, no, sorry, let's go to page 148. Apologies. It's 1189 of the bundle, I think, for Crown Law, if that's helpful. Great. So if we look down the middle of the page again, maybe, sorry to be a pain as the non-driving person. Here we go, blow up Te Puni Kokiri. Just that first bullet there, national and regional officers to provide advice and assistance to CDM groups, local authorities to link to marae that can assist with shelter and emergency accommodation and manaakitanga. See, again, building on our discussion, that doesn't quite seem consistent with what you're telling us today. It seems a bit of an oversimplification.
Certainly it's a reflection of the time and the arrangements at the time. And I think actually it's indicative and it shows how things have advanced in the last 11 or so years. Because I still see that there is a critical role for Te Puni Kokiri and their regional officers and their knowledge and relationships with iwi hapu marae to be a really important part of the emergency management system and provide advice, but ultimately local authorities are the key recipients of that information and should be having those direct engagements with iwi hapu marae.
So I fully understand your previous answer as a careful public servant that you want to do the policy work first, but are you sure you don't want to agree with me that these documents are probably likely to change quite a lot when you get around to updating them?
I think there will still be a really critical role for Te Puni Kōkiri, but
Sure.
certainly it's an and is the way I'm viewing it.
Cool. I think I'll leave it there, Mum.
Our next questions are from Te Whenua Law, Mr. Whenua.
Korua, kei konei ahau, kei rungi te whakātu atu marungi te purangi. Are you able to hear me okay?
We can, thank you.
Great. Tēnā korua, my name is Tania Te Whenua and I'm legal advocate for Te Aroa Climate Change Committee and Ngāti Ue Pōhatu Hapu, who are located within Ngāti Porou, the Waiapu catchment area in the Tairawhiti. As you'll know, significantly impacted by significant weather events of 2023. So in asking my questions today, I'll be referring to the evidence that Ngāti Ue Pōhatu in particular have provided around emergency response and predominantly to the brief of evidence of Dr. Sean Awatere, which is A80. Now, the first kaupapa that I'd like to ask questions on is acknowledging the role that Māori have played in emergency response.
Apologies, would you mind repeating that?
You have the brief in front of you?
We do.
Ka pai. At this point, I'm actually looking at your paragraph 14 of your evidence where you acknowledge the critical role, in your words, that Māori communities and organisations play in responding to emergencies, which of course our witnesses and claimants tautoko in full. Dr. Awatere describes the role as one of Māori necessarily needing to step into leadership and emergency response leadership where there is a gap. In his evidence and the evidence of Tui Wāmanhoven, who's the head claimant for Ue Pōhatu, that gap has been left by local authorities in the Crown, particularly with respect to the 2023 emergencies. Would you agree with that?
I wouldn't say I agree. I think, again, it goes back to the comments we made earlier around the different capabilities, resources of every district and region, and the fact that some councils, obviously there are finite resources at every level for emergency management, but certainly some regions or districts may find themselves with fewer resources at their disposal. The way civil defence centres ordinarily operate or are stood up, which goes back to the Welfare Services Director's guideline that was up on the screen before, is they are the responsibility of local authorities to stand up and establish. Traditionally, they'd be in school halls, community halls, but they obviously vary across the country as well, particularly with new developments where these facilities actually exist, these council assets. And certainly the evolution for marae to open their doors, which we've certainly seen increasingly in recent years, it has never been an expectation, I would say, of local authorities. It's been something that's been remarkable and very much supported but it's not seen as something that should absolutely happen instead of a local authority equally carrying out their responsibilities. I think the question I would have is where communities are more isolated or rural, whether there are those, what's the ability for local authorities to get into those communities rapidly? And this is where, even beyond Māori, this is absolutely just for all rural communities, the reliance on communities self-mobilising and having a degree of community resilience is absolutely at the heart of emergency management. We can't shy away from it. We simply all have to take that responsibility. So I'm not sure if that's answered your question entirely or directly.
I think it has. I think it's been a nice comprehensive answer. I think what I take is that you acknowledge that in some more isolated areas it's more difficult for central, local government and those who are resourced by them to get into those areas and provide a swift response. And that in those cases, it does fall on those communities such as Māori who are on the ground to fill that gap. Would you agree? I do, and I think, and it goes beyond Māori. I would suggest it's all rural and isolated communities, but that is not to say that local authorities, they should be planning for it. They should be working with those communities, especially given they can be more isolated. It's even more important that they actually have plans, that they know what to do, that they have potentially pre-identified sites, for example, that become safe centres for affected communities. Yes, certainly, and I would agree with that. Yesterday we heard from Paula Rawiri, your colleague, in the broader sense of the term, from Te Puni Kōkiri, who in their evidence pointed out a mapping tool that they've developed which shows those critical areas of vulnerability, and acknowledging the fact that it's well known that Māori communities in those isolated areas are often more vulnerable and more at risk for a number of reasons, including the fact of their isolation notwithstanding, the fact that they're coastal and other factors. So I think we both agree, and correct me if I'm wrong, that often Māori communities are more vulnerable. And first I'll ask you if you agree with that.
I do.
And more isolated. You're nodding, but
I do.
I'll let you agree for the record.
Apologies. I do, and especially on the grounds that these are the findings of recent government inquiries as well. That there is that disproportionate impact, particularly for rural, isolated communities that can tend to be more Māori in their makeup.
Yes, indeed. And so you'd agree they're often more isolated. You're both nodding. I welcome Mr. Hendrick's view as well as to the extent to which then in that circumstance swift emergency response is so critical, and the fact that Māori are playing such a significant role becomes so critical also with community response. You would agree?
I would agree.
And you agree also, just for the record, because I see you nodding, Ms. Rogers, with that proposition?
Yes.
And I know that you did acknowledge that it's not limited to Māori, that emergency response is a collective response in your answer to me, Ms. Rogers, but in the context of Te Tiriti, which is the focus of this tribunal, then, and given how vulnerable Māori are, would you agree that the role that they play therefore in the context of Te Tiriti as a Tiriti partner should be elevated?
Yes, and that is absolutely the ambition of the new emergency management bill.
Which is fantastic. One thing I noted about the new bill though, the new emergency management bill, was that I couldn't see in your evidence a reference to a treaty clause in the bill is there a commitment to te tiriti being proposed in the new legislation?
I can only talk to the bill that was made publicly available in December, but I can't talk to the bill that's currently, as that bill is now progressing through Select Committee, as to its current state.
Sure, please feel free to talk to the bill as you're aware of it. Is there a commitment to the treaty in the form of a treaty clause?
No.
No. Is there a commitment to the treaty in our current legislation?
No.
No. And given that when Māori step up and they step into those gaps, as we've acknowledged, they do so well given the nature of the treaty partnership, do you think that this is a gap in the proposed legislation?
As I understood it in terms of the advice at the time, no. I think there had been discussions and advice around operative versus descriptive treaty clauses. And very happy to follow this up in writing because I'll probably clumsily just cover this off if it's a written question. The descriptive clause that was in the previous EM bill, because of course the current emergency management bill is the second of its kind. The first was redacted. There had been a descriptive treaty clause in the first bill, to my understanding, which actually just represented the way in which te tiriti was being honoured through the various changes, such as having iwi Māori on coordinating executive groups, or the requirement to involve iwi Māori in planning, etc. So the removal of that clause has not been seen as, in terms of the emergency management bill that was introduced in December, was not seen as being a reduction of sorts, given the provisions are still in the actual bill, the requirements.
Right, well, let's have a look at those requirements. In the context of what is being proposed, is there recognition given to, in terms of Māori, in the terms of the importance of Māori leadership in the context of which we've just discussed, is there recognition of rangatiratanga in the proposed legislation?
Your Honour, to sort of seek the Tribunal's guidance here, I wonder whether the best way to deal with these questions about the bill currently before the House is for these questions to be addressed in writing, just because the witnesses is put in a rather difficult position in terms of balancing both parliamentary privilege issues as well as the Tribunal's jurisdiction. That's not to say we're saying no to answering these questions, but I wonder whether that would give the witnesses, put them in a less difficult position in terms of dealing with these questions.
Ma'am, if I may respond, the evidence on the proposed bill is being put forward by these witnesses, and they have discussed the nature in which Māori participation is proposed under the bill, noting that CEDAM groups under the proposed legislation are required to engage with Māori, as is the Director General of the specific agency under the legislation, the requirement being to engage with Māori. The nature of my questions can be reworded just to focus, if you like, on that specific, the nature of engagement around being required to engage with Māori as opposed to partnership, for example.
Could you just make further submissions, Ms. Te Whenua, as to give me an example? The tribunal is in the position that it can't make any findings or recommendations in relation to the bill anyway, and we're not sure what it will look like when it comes out, when it finally passes into law. So, yes, perhaps if you can give me an example of the kind of question that you're thinking of asking.
Certainly. I've asked this question for your benefit, Ms Rogers and Mr Hendricks, and in response, Your Honour, of previous witnesses, and it pertains to Dr Shaunawatere's evidence where he's critical of the emergency management regime and that it does not uphold te tiriti principles of co-governance and partnership. The specific question I'd like to ask is whether these witnesses agree with that in the context of the current legislation and in the context of their understanding of what's being proposed.
Well, is your question really whether there should be co-governance and co-management by Māori?
That's another way of putting it, yes.
All right, put it that way, thanks.
Thank you, ma'am.
So the question is, should there be co-governance between Māori and this official CDM?
Yes, I think it covers every level of government, so both in terms of your organisation, but also in terms of the regional bodies that might be involved in emergency management.
NEMA obviously has its own partnership with iwi and Te Tiriti, and the Crown has its position in relation to governance. For the EM bill, in terms of the version that was introduced before the House, as I've said earlier, there is a policy proposal for iwi Māori to be members of the coordinating executive group at the regional and local levels. Important to identify that the KEG, which really is the body that gets things done, it implements the decision-making of the Joint Committee. And the Joint Committee is made up of the mayors, the elected representatives of the local authorities. And if you're looking at it through that lens of governance, those two bodies are both governing emergency management in the regions. I think that's a marked improvement. There can be the opportunity for joint committees also to co-opt Māori iwi as members onto the joint committee, but I would have to again probably look to provide this answer in a better written format, because I do understand there are limitations to that in relation to other wider legislative instruments around local elections and what have you. So I couldn't answer that more fulsomely, I'm afraid.
Further elaboration in writing would be much appreciated, and in particular to those limitations. Thank you. I guess an additional factor that is raised by Ngāti Ue Pohatu and Dr. Shaunawatere is that overall the Crown structures within the Crown's regime, and that in his words, at paragraph 69 of his brief, a more treaty-compliant approach would mandate Māori under a co-governance or partnership approach in a manner that supports local governments along with iwi and hapu. Would you agree with that?
Sorry, we're just reading it now.
Sure.
Regional adaptation frameworks that supports local government along with. So I assume this is in relation to the adaptation framework, the National Adaptation Framework, that he is talking to here?
The overall, the tenet of his point is that whilst the Crown takes certain steps, the role of Māori within the regime is still within a Crown-directed kawanatanga space, if you like, and that a more treaty-compliant approach would mandate co-governance or partnership approaches, Māori-led solutions, for example, as opposed to community-led solutions, Crown-enabled. Māori-led solutions, Crown-enabled. The language which I don't see at all in your brief of evidence with respect to Māori-led as opposed to community-led. So coming back to Dr. Awatere's point, a more treaty-compliant approach would mandate co-governance or partnership approaches in a manner that supports local governments along with hapu, iwi and Māori communities. Would you like to comment on that point?
I think the key with the current Civil Defence Emergency Management Act and even the Emergency Management Bill, as it was introduced in December, is it's looking at whole of society emergency management practice or roles, responsibilities to keep the public safe. And it goes well beyond the Crown and local government, lifeline utilities, emergency services and beyond. I think the advances that were proposed to identify and recognise and strengthen the role of Māori is a positive step. The decisions that have been made by the government of the day are the decisions to date. I can't really talk further to that.
Mr. Whenua, we've reached, we're past the lunch hour.
No, actually, ma'am, that would be my last question, but the only other thing I wanted to do was offer Mr. Hendrickson an opportunity to comment also before closing. With your leave, ma'am.
Yes.
Thank you.
I acknowledge Dr. Awatere's perspective. Just one of the things that I would highlight within the existing system is how we partner with local government and through the development of CDM group plans and the role that iwi Māori play in terms of informing the risk assessment processes with that, and in terms of the development of national products and how we partner and engage with iwi Māori to have those perspectives in the development of those national products. That is something that is already in existence.
Just one final question, ma'am. I promise that's the last, and then I'll let you eat. Would you agree that engaging with Māori is highly different, Mr. Hendrickson, to partnering with Māori?
Engagement with Māori and many communities all looks very different, and I do acknowledge that engaging with iwi and hapu and Māori organisations can look different as well. So the way in which we engage needs to be appropriate for those we're engaging with.
Thank you. It's different to partnership, isn't it?
Yes.
Thank you. Thank you so much. And thank you, ma'am, for indulging me. Those are my questions.
Thank you. We will take the lunch break now. We will take the full hour because we are still somewhat ahead of our schedule. So we'll return at 1:40.
Sorry, Mum, just before we go to the lunch break, I do have to seek leave to be excused for the afternoon. Unfortunately, I've had a backup fixture turn into an urgent firm across the road at the district court.
All right.
Thank you, Mum.
All right.
Tēnā koe, Mum. Apologies. If Mr. Lau could briefly update you on a timetabling matter?
Yes.
Thank you.
Yes, thank you.
Kia ora, Your Honour. I don't want to keep people from lunch. The cross-examination requests for hearing week 8 are due today and the timetable is due next Tuesday. Given that there's been some chopping and changing, I wonder if we might have leave to file a draft timetable on Tuesday, cross-examination requests Wednesday, and then a final timetable at the end of next week.
Yes, that's a very sensible suggestion. So I accept that recommendation, Mr. Lyle.
Thank you, Your Honour.
All right. And it's not just because I want to go and eat. All right, so we're back at 1:40. Welcome back from the lunch break. Welcome again. I hope you had a decent lunch. Just before we resume questions, we've been discussing timeframes for Mr. Shaw to give his evidence. We were hoping that he would be able to come a bit earlier than scheduled. I think he thought he was on at 4 o'clock. It seems that he may be able to make it at 3:30, which is the time in the timetable for him. We will probably, I'm anticipating that we will finish questions to our witnesses a little earlier than expected. So we will take a longer tea break than expected and come back, perhaps just 5 minutes before 3:30, just to make sure the connection to Singapore works and so on. So if you can come earlier, we'll let you know in the meantime. So our next questions are from Mr. Sharp for Woodward and Woodward Law.
Thank you, ma'am. Tēnā kōrua, just checking you can hear me.
We can, thank you.
Thank you. Yes, my name is Michael Sharp. I'm representing a number of claimants in the inquiry. Thank you for your evidence, which I found very interesting, and to see that things are progressing in the emergency response field. a lot of the questions I was going to ask have been asked, but I just want to just discuss with you one particular part of your evidence. And so if you could go to paragraph 175 of your evidence. And this just discusses the NISWE inquiry report that took part in 2024. Can you see that?
Yes.
Yeah. Now, the first question is that you say officials invited iwi leaders affiliated with Pautaki Ahurangi from the National Iwi Chairs Forum to provide views from a Māori perspective. Just want to clarify with you, is that the usual process with Māori consultation, that you just deal with the National Iwi Chairs Forum?
I'll explain the background to this arrangement. The minister met firstly with Marama Royal and with Kerry Allen, who I think was obviously leading the Pautaki Ahurangi at the time, and discussion was had around how can the National Iwi Chairs Forum meaningfully support the minister in the development of the Emergency Management Bill, and certainly their discussion landed on working with NEMA directly through this particular PO, having already identified a number of iwi leaders with a real, not just an interest, but a lot of experience in the matters around emergency management and climate change and climate adaptation. So we actually contracted Kiri to work very closely with NEMA in the development of our work, and that was in relation to both the government inquiry response alongside and its findings alongside the bill. So that was the way in which we did carry out that work for a good 15 or so months. We would hold particular hui with those representatives, test the findings or test policy proposals, and there have been other engagements beyond just that group as well, though it has gone more broadly to other iwi representatives as well.
So I think what you're saying is that this engagement wasn't on the basis that this PO represented all Māori, but just it had particular expertise in the area which you were engaging with. Would that be the correct summary?
Yeah, and I think given the timeframes that we were having to develop a lot of the work, it was presented to us in many ways as a really advantageous avenue to coordinate, a mechanism by which coordination could be carried out to support a much wider group of iwi feeding into the work as well.
And with this particular consultation, with regards to this inquiry, was there any wider consultation with Māori apart from the Iwi Leaders Forum, Iwi Chairs Forum?
I don't think so. I think that was the extent of it. Certainly, the NICF did its own internal wider consultation, but certainly the PO and the smaller group would be the group that would then represent the feedback, if you like, and walk and talk us through it.
Thank you. Now, I just want to move further down into paragraph 175, where the Iwi Chairs Forum highlighted views with regards to emergency management, and they make 4 points there. One about manaakitanga, one about iwi having formal participation in CDM groups, another about localised hapu and iwi mataranga should be recognised, and then lastly that Māori should lead the localised emergency management response. Now I just want to contrast that. If we move down to paragraph 178, and this is the decision of the government on its overall direction of travel as a result of the inquiry. So the decision of the government was part of what says give effect to whole of society approach to emergency management. And one is to recognise and enable significant contribution of iwi and Māori emergency management. Another, to expand number and quality of formal arrangements with various community organisations, including iwi and Māori. So it seems that that's a lot less in regards to Māori participation than recommended by the iwi Chairs Forum. That would be correct, wouldn't it?
I think the marrying there, what I'd highlight is that's focus area 1 out of 4, well actually 5 focus areas in the government inquiry. And if I look to the list of feedback from the iwi Chairs Forum, I would suggest they touch on other focus areas alongside one. It's difficult without the document here. Focus area 1 is all about really reaching into communities and supporting their preparedness for emergencies. It had recommendations around things like significantly bolstering the CDM Resilience Fund that I talked about earlier, which for context has only $889,000 in it. It has not been inflation adjusted in 40, 50 years. So really looking at significantly investing in such a fund to genuinely be able to enable that focus area. It also had, like it says here, sort of the expansion of agreements right through to community level and preparedness activities. If I go back to the other page, 175.2, iwi should be formal participants of setting groups in their KEG. The government inquiry roadmap doesn't look to address things of a legislative nature. That particular one's getting picked up in the bill, for example. And I would also suggest that 175.3 is also getting picked up in the bill, and probably 175.4. So the way we describe the bill and the roadmap is they're almost two sides of the same coin. If the coin is to strengthen emergency management, we've got to hardwire it in legislation and we've got to enable it with investment, and that's where the roadmap comes in. So equally complementary.
I understand. So if, in that context, if we just turn to what was picked up in the bill, so that's in paragraph 65 of your summary. So it seems that the participation recommended by the iwi Chairs Forum is what's picked up in the bill is not as strong as recommended by the iwi Chairs Forum, for example, leading responses in local areas, things like that. Would that be a fair observation?
I'd have to go back to the National Iwi Chairs Forum submission to be certain. My recollection is around, in terms of 175, let me just go back to that, actually. My view is they're not mutually exclusive. The role Māori play, and it's an increasingly organised role, which is unique, I think, unlike any other community group in the country. in terms of the ability to self-mobilise, connect, the networks, etc. It is almost like an organisation alongside local government and the other organisations that play a role. The point here, 175.4, Māori should lead the localised emergency management response as both part of Te Tiriti partnership and recognition of a locally led emergency management response. I'd have to look into the detail of that again to doubly be sure of this, but I don't think it's in. I think it's in addition to local authority emergency management response, not instead of. If that's what you're.
Well, no. The point I'm just trying to flesh out is have the iwi Chairs Forum recommendations, in essence, been picked up in the bill?
I think they have. We may not have. They may not all have been exactly as they had fed back, but certainly I think, and it's not just the bill, is what I'm also pointing out here. I think it's really important that aspects of this get picked up in the bill and aspects get picked up in the government's roadmap, which is really about the implementation.
Yes, and we've just discussed in the roadmap, it doesn't particularly pick up the points in the iwi Chairs Forum recommendations. So that's something we just did discuss, didn't we?
Well, I think it's a combination across those two strategic pieces of work.
Thank you. Now, the other thing I just wanted to speak to you about is that one of my client's witnesses, Barry Suter, he gave evidence in his brief of evidence, which is at reference A10, about the events that happened at Gabriel to his local marae and community at Tairāwhiti. And he was discussing what could be done better next time to help them. And his comment was that they had quite a catastrophic floods and collapses of earth and soil around there where they lived in their marae. And his comment was that they got food parcels, but what they needed was machinery to clear away the soil and debris from their houses and vehicles, and that was very slow in coming. So I just wonder whether you want to make a comment on that concern, that sort of concern about support.
Thank you. Oh, apologies. Do you have? Is there a particular paragraph in his brief of evidence? Just so we could have a look at it.
Yes, have you got his brief of evidence?
We do, thank you.
Yes, thank you. Paragraph 27.
Thank you. I would suggest, I would be so brave as to suggest that that's not entirely unique. I think this goes to the heart of the challenge in emergency management during events, especially as to how rapidly damage and needs can be collated and understood by those that are coordinating the emergency response. Certainly, especially when it comes to heavy machinery and the sorts of things that may need to be deployed to fix damage or remove debris, etc., that can certainly take some time. There's very finite resources, and so damage assessments, rapid damage assessments, really need to be carried out as swiftly as possible, including reconnaissance, especially if communities are cut off. So that's often done through flight, using Defence Force or any other assets that are available, but then the bringing together of that necessary information to inform and support the deployment of various resources can take time. And that's certainly not just unique to New Zealand, that's a global, I'd suggest, experience. So noted, I can't really talk to this exact experience on the ground other than to acknowledge that it is in fact part and parcel of emergency management. Unfortunately, it can take longer for certain resources to be deployed.
I appreciate that. And one thing I just want to clarify is that you said in your summary at paragraph 54 that resourcing is primarily dependent on local government resourcing. But what would happen in this situation if, for example, local government didn't have sufficient heavy machinery to go in and clear areas for people? Would that be funded through centrally funded through emergency management work that you discussed in summary at paragraph 55?
Certainly, as many assets that can be requisitioned and utilised locally and regionally, that's the most ideal outcome. The powers that are afforded controllers when they do declare a state of emergency means they can requisition and use a raft of resources available to them in that region or wherever the locality of the state of local emergency is declared for. The key of that devolved model is to use all resources and ensure that they are made available to that controller on the ground. When that is exhausted, the way the system is designed is they can then, in many instances, they may have actually arrangements with their neighbouring CDM group, so they can draw from them for further resources, or if they need to, they can make requests to the national level, and that's the role of NEMA and the National Coordination Centre or the National Crisis Management Centre. And that's for local authorities. Of course, it could be that there are many other agencies on the ground alongside local authorities, such as New Zealand Transport Agency, who may also be operating and be using their own equipment and resources to clear debris, clear roads, those sorts of things. So it's not just local authorities. But certainly the model is to use and exhaust as many resources and to requisition as many resources as is needed. If that isn't sufficient, then to go across the boundaries to neighbouring regions and CDM groups if they haven't been affected themselves, and then of course to the national level. And it's one of the, I would confirm that is pretty much from the moment an event happens, one of the top priorities of NEMA is consideration of need with capacity and capability on the ground. That is fundamentally what we are focused on right from the outset, because we know, particularly if the event's looking like it's quite large scale, that those resources are really finite.
Thank you for your answers. Those are all my questions.
Tēnā kōrua. I'm just behind the room, at the back of the room. Kia ora, kōrua.
Kia ora.
My name is Ms. Swedland and I represent several clients, Te Upukorehe, Te Waimate Taimai ki Kaikohe, Ngāti Ruapani ki Waikare Moana and Ngāti Parau ki Hauraki. So I would just like to turn first to the brief of evidence of Ngaire Ngā Moki for Te Upukorehe, which is at A45. It probably would be great if that could be brought up. Or just placed in front of the witness, I can read it out. Okay. So just at paragraph 33, so Ms. Ngamoki notes that from the 25th to the 27th of May 2021, a NEMA conference hui a motu was heard to seek Māori and Indigenous perspectives on emergency management. And then just turning to 34, Ms. Ngamoki says that we left that hui with a kite full of knowledge A kite full of promises, but no solid outcomes for our whānau. We were no closer to solutions or support, or any closer to sourcing funding to support our communities. So I know you've already referred to holding these kinds of hui a motu, but how often are these kinds of hui a motu held by NEMA to get perspective from mana whenua on emergency management?
Sure. I'd say there have been two key ones that were as large as this. This hui a motu was specifically for Māori iwi and for emergency management practitioners as well, to bring those two groups together. It was a 3-day hui, and it was very much at the beginning stages of scoping the emergency management bill and wanting to hear directly from Māori and iwi, and particularly those iwi that had experiences that had led to, of course, this is all before Cyclone Gabrielle, that had led to the previous ministerial review findings, whereby the government had again accepted them, and it was leading up to the establishment of the new emergency management bill and the new agency. So NEMA as an agency had only just been stood up. I think we were probably 4 months old at this point in time. No, apologies, a year. So 12 months or so in. So the intent, it was quite a unique hui. It's not something that we do get to do all that often. And the first day was only for Māori iwi and NEMA to hear firsthand of the experiences and the wishes, if you like, on how the government and the Crown could take forward those government inquiry findings.
Sure.
That led to a lot of the development of the policy proposals that led to the development of the first emergency management bill, which I've discussed earlier, and which was discharged for the second bill. And a lot of those provisions have carried over into the second emergency management bill. The second wānanga that I referred to, which happened probably 12 months later in 2022, was similar again, but was more about testing through the development phase of that bill. There was a second aspect to your question that I've forgotten, apologies.
No, I was just wondering how often they were held. So there's been two generic hui a motu for iwi and hapu Māori specifically to feed back on the bill.
To really help NEMA to develop, I would suggest, the policy proposals that are still now with the second round, making their final way through the bill-making process.
Sure. And would you prefer to hold that kind of hui and get that kind of feedback more often as an agency?
Yes would be the short answer.
Yeah.
I think the real challenge for NEMA, especially in the last 3 years, has been, since Cyclone Gabrielle especially, has been the tempo that we are finding ourselves as an agency responding to so many events. It's an extraordinarily disruptive period, I would suggest. And certainly these hui, they take and they require a really strong focus. I think for us, when it comes to bill implementation, that presents a really important opportunity as an agency and as a sector, and more broadly as a system, to bring all parties together, but especially iwi Māori, to support that implementation phase.
So you mean there'll be more in the future? And so I guess the underlying point would be more resources would allow you to hold more hui?
That's a fair enough assessment. I think it's also timing, though. I think when we held those two key hui, it really was around policy development and really supporting that process. The next key opportune time really will be implementation.
Yeah. And so just shifting to the current CDM Act, so this current Act makes no specific provision for Māori representation on CDM groups, and that's correct, isn't it?
Correct.
So I guess that means that if there's no concerted effort from CDM groups to have representation by Māori on that group, they are reliant on outside engagement with mana whenua to get that Māori perspective?
in the summary of evidence, I'm not sure if it was noted, at present, whilst it's not in the Civil Defence Emergency Management Act as a requirement, but will be going forward, 10 out of the 16 Civil Defence Emergency Management Group joint committees have Māori representation on them, and I think it's 12 or 14 of the 16 coordinating executive groups also have Māori representation on them.
Sure. But outside of that, they would have to seek that specific representation outside of... I'll move on. So would you agree with me, though, that given the large geographic areas that CDEM authorities cover, even if one Māori representative is provided for, as is in the case in the new bill, partnership with mana whenua at a more granular level would still be crucial?
Yes, yep, absolutely. I think important to note that the KEG and the Joint Committee are the ways in which, I guess, decisions are made, the choices of prioritisation of work and programs, planning, etc. But there's a huge amount of work that happens outside of those committees. The bulk of it, I would suggest, and I think absolutely that's where it's critical that those relationships, firstly, are in place, and that work is carried out in partnership.
So at paragraph 39 of Ms. Ngāmoki's evidence, if you still have that on the screen, she recalls that in 2023 a hui was held by CDEM in response to the evacuation from Cyclone Gabrielle, and she states there that they had no responses to the recommendations from the community that were given, nor response to our specific requests for information on emergency supplies and training. So I guess this kind of one-off hui is consultation, but you would accept that this isn't ongoing engagement or partnership.
So this example is at a local level versus NEMA?
Yeah.
So I'm just trying to make the correlation between NEMA's hui and this
Oh yes, sorry.
example.
So this is a CDEM hui. So this one is...
This would be a local authority, I would imagine.
But would you accept that CDEM groups who don't prioritise ongoing relationships with mana whenua can miss opportunities to support and upskill those communities in emergency preparedness?
Please repeat the question.
Sorry. So would you accept that CDEM groups who don't prioritise these kinds of ongoing relationships with mana whenua can therefore miss opportunities to upskill those communities in emergency preparedness?
Yes.
And you would agree, obviously, that the director's guidelines are part of the CDEM framework that have most comprehensively addressed the issue of Māori engagement? Or would you agree with that?
They absolutely do, in terms of a lot of the how and what to focus on for those particular functional areas. However, I think it's also important to recognise the National Disaster Resilience Strategy, the Crown's strategy for emergency management, which is whole of society, local authorities, lifeline utilities and beyond, need to, or all play a part in achieving, does also set out the importance of engaging, partnering with Māori.
Sure. And is there any, what is the sort of direction that strategy be taken into account by CDEM groups?
They need to be, I can't remember the exact language, they are not to be inconsistent with or need to take account of the National Disaster Resilience Strategy.
I can ask that in writing if you'd prefer to check the... Yeah, perfect.
So their CDEM group plans, their regional plans, which really are about how they will work with communities. They identify the hazards and risks in their regions. They then outline the roles, responsibilities, etc. They do have a requirement to both take account of the director's guidelines and the development of those plans, which will have advice on engaging and working with Māori iwi, as well as not being inconsistent with the National Disaster Resilience Strategy.
Would you agree that for these areas covered by CDEM groups that have a low rating base, that their engagement with Māori is occurring within the context of already stretched CDM resources?
Yes, absolutely. And I think that's common knowledge in terms of the findings of recent reviews.
So I guess in the context of stretched resources, it makes sense that, would you say CDM consultation with Māori can sometimes be ad hoc?
Yes, I'd say so. And I think, again, there has been recommendations for local government who have a lot of different functions and responsibilities, is to really think about how they can best engage with Māori iwi in a way. It's emergency management, I guess is what I'm saying, is just one function. So there are probably many other opportunities and avenues for them to engage with iwi Māori, not just through emergency management.
Yeah. But again, that is sort of dependent on their resourcing and their ability to prioritise that engagement with iwi Māori. If you don't mind saying yes.
Yes, apologies, yes.
Thank you. And another theme of Ms Ngamoki's evidence is that despite holding knowledge on effective community responses and disasters issues, they lack the monetary resources to put that into practice. So you've noted that marae can be reimbursed if they're used as civil defence hubs and expend resources that way. Is there any way in which the emergency management system can ensure kaitiaki on the ground proactively have these kinds of resources to effectively support people?
There is, through the Civil Defence Emergency Management Resilience Fund, like
Yes.
I've mentioned a few times. So there have been projects that have been funded through that avenue that have actually invested in kit, could be telecommunications, sort of things that build resilience for, could be other resources. I know Tairawhiti, for example, have done a number of these projects. So through that avenue, absolutely. I think this is where we've really, we are prioritising work to review our current funding, Section 33 of the guide it's called, broadly at present, to see if there are other ways to recompense and reimburse marae, because it is quite different. And we have got experience and feedback around the fact that, for example, marae may have their freezers full in advance of an emergency, which is extraordinary in and of itself, and they may not have kept receipts, and it's all about a reimbursement model, so that's not really appropriate or easy. So these are the things that we are looking into at present, how to make that far more effective and efficient for Māori iwi.
Because also the fund only, as you said, has, I think it was 880,000.
I'm confusing things there. So the Resilience Fund, yes, has 900 odd K per year for particular projects, for things that could be like a container with certain kit in it, which is not for welfare purposes. It could be telecommunications or something else altogether. It could be for planning. So they've got the opportunity to tap into that resource pre-event. But for welfare-related costs, that's actually unlimited.
Right,
so
but that's the reimbursement model.
That's the reimbursement model, which may not, it's different for a local authority who maybe spends in the moment and has invoices in the moment, versus marae may have already got resources in-house that they use that they haven't retained invoices for. So these are just some of the complexities that we have to work through.
Sure, and this, so the CDM Resilience Fund in particular, is it a contestable fund? Do
you want to talk to that?
Yes, it's based on a set of principles and allocation processes.
Yeah.
And all of that information is available publicly as well.
Okay, perfect. But would you say this fund is oversubscribed?
Yes.
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 Yes. By quite an extent, or?
Some years it can be. I think it really wavers from year to year. $889,000 is not a lot of money.
No.
And so it's, I think it's also, it can go more towards community level initiatives, but it's certainly, some years it has gone towards bigger projects like the Alpine Fault project in the South Island. So some big sort of whole of, or half, in that instance, many regions, 6 regions that received the funding. So it can go to large projects or to a number of small projects.
Yeah. And is you doing work on increasing the pute in that fund, I understand?
This is part of the government's roadmap in
Yeah.
terms of focus area 1 I talked about before, that real genuine investment to that community level. The Resilience Fund has been singled out as a really critical component to achieving that ambition, and that's what has been agreed by Cabinet in principle.
Yeah.
We've obviously got some further work to do policy-wise in advising on what that looks like, and of course out-year budgets needing to be made available to bolster that fund.
Sure. Are you able to say how much it's going to be bolstered by?
No, that decision has yet to be made.
Sure. Would you agree on the whole Ms Ngamoki's evidence reflects a kind of disconnect between mana whenua who are ready and willing to assist with emergency events and I guess the ability of the emergency management system to leverage this kind of assistance?
I'll attempt to answer there, and you may want to as well. I think firstly it's really important to acknowledge that there are different relationships all around the country, different experiences. Some districts and regions and communities have been hit multiple times and may actually have developed some quite deep ways of working alongside one another, but I would suggest it's highly variable across the country.
Just two more questions, if that's all right, Ma'am. So these are questions coming out of cross-examination of Ms Casey before. So the efforts led by Ms Casey to build up sort of a lot of institutional knowledge on managed retreat in the context of the whenua Māori and Marae pathway, and of course building up the relationships with those people on the whenua throughout that process. What steps are being taken by NEMA to ensure that that institutional knowledge isn't lost?
Good question. I think, I'm not sure whether Katrina touched on the policy and where, because of course Cyclone Recovery Unit has stood down.
Yes.
Right, and so the policy settings, and much like recovery more broadly, there are, probably at least a dozen to 20 key agencies in government that administer different policies that support recovery, and managed retreat being one of them, which is led by the Ministry for the Environment. So we are very much, as a steward of emergency management and of good risk management practice, we have a very strong interest in that policy and how it is advanced and continues to be advanced. When the Cyclone Recovery Unit was stood down, as I understand it, that work transferred to a number of parties, including MFE, DIA and DPMC, and NEMA continues to be, I would suggest, a supporter of its development.
Sure. In what sense?
I see it being folded into the adaptation work. The reference in the National Adaptation Framework that was published last year, I'm assuming MFE would have touched on this, in terms of Minister Watts's work, the three different, is it 3 or 4 pillars, apologies, 4 I believe it is. The last pillar there around cost sharing talks to the Minister returning in the next term with this policy having been further developed. So obviously in terms of government, we all support the various work programs to ensure that they are dovetailing, they are working, especially given we've got so many concurrent reform programs, and that the lessons, particularly from various events, are feeding into those policies being developed. So I anticipate FOSL or Whenua Māori, as it was known, will be being advanced through that work and is being advanced through that work.
And you may not be able to answer this, acknowledging that you're from NEMA, but are you aware of where this program of managed retreat led by the Ministry for the Environment will be after the proposed merger of the Ministry of Cities, Environments, Regions and Transport?
My understanding is all work programs and government priority work programs are just continuing.
Sure. And last Lastly, Ms. Casey said that NEMA has links with local communities already for recovery, and you've spent some time talking with my friends about how NEMA encourage and influence local council to build relationships with mana whenua. Is there a process for Māori to directly approach NEMA themselves where councils are choosing to not engage or choosing not to declare states of emergency, or as we've seen recently?
I wouldn't say there's a formal process, but the relationships are developing and advancing more and more, to the extent that iwi leaders are picking up the phone. They will call our chief executive or our mayor for that matter, and they are always, we as an agency or our minister is always, did I say mayor? Minister. Are always highly responsive to that. I do also think because of the very active engagement we've had with the PO and with Kiri and with Marama, they too would reach out, especially if during a response something is unfolding and there is a disconnect. I mean, that's absolutely the kind of thing we want to know about.
Sure.
We, especially over the most recent weather events, are just a case in point, particularly in January and February, we hosted or held every 2 days meetings between all local government chief executives and iwi leaders across all affected regions to flush out what was happening on the ground. Were there issues? Were the relationships in place? And that went on for at least a month.
But I guess the only issue with that kind of approach is that Māori would need the institutional knowledge to be able to know that they can raise this with NEMA.
Yes, correct. And I think it's the kind of thing that just happens naturally with those relationships being in place, which is why we need to continue to be building those relationships.
Great. Thank you very much. Those are my questions, Ma'am.
Ms. Rongo. Oh, Mr. Messi.
Oh, thank you, Ma'am. Tēnā koroa, ko Mr. Messi tōku ingoa, and I'm here on behalf of Ngāti Koata. Ngāti Koata is a small iwi at the top of Te Tauihu, around Whakatū and the Marlborough Sounds. Now, have you read the evidence of William, who also goes by Bill, and Ngāwai Weber? That's A90. That's okay if you haven't. The evidence is on the storm that was in August 2022 that caused flooding and many slips. Now, Bill and Ngāwai are in their 80s and they live in French Pass, which is a rural and coastal isolated area in the Marlborough Sounds. My first area of question, you were talking with Ms. Te Whenua around rural isolated areas and Māori are disproportionately affected. And you would agree that this is by climate-related emergencies such as flooding, coastal inundation, and severe weather events?
Correct.
Thank you. I'm just jumping around a bit, sorry. Now my next part is on response. And you said in your summary that response is the action taken immediately before, during, or directly after an emergency to save lives and property and to help communities recover.
Sorry, I missed the beginning of your statement.
Sorry. The response of actions taken immediately before, during, or directly after an emergency to save lives and property and to help communities recover.
Correct.
Now, during the storm in 2022, there was flooding and slips, and they were isolated, like I said before, and there was damage that caused their septic systems, that contaminated their water, and roads were blocked and they had no access to shops and resources. But lucky whānau and friends were able to access them by a boat to help them with cleanup and bring different resources. They brought fresh water as well as a portaloo. Ngāwai, during her, actually slipped and had to be flown by helicopter to the hospital. And my first question is around the response team, engaging with people in emergencies. Now, the Marlborough District Council made the journey before the road opened, and we found it interesting because they did not bring anything. They didn't bring any resources, water, or even food, but they did ask if Bill and Awai could let them know what their needs were, which at the time they didn't know what they were. Now, is this in line with the advice and guidelines you give for response in emergency?
It can be done one of two ways, I would suggest. I can't talk to the exact guidelines here, but plenty of years of experience in this space. I would suggest it depends how they were getting around. I don't know if they may have exhausted any resources they had taken out with them, because they may very well have. I mean, ordinarily, if people are going out to find out the needs of isolated communities, they will take resources. If you've got space in the helicopter or however you're getting out, you'll definitely try and attempt to do so. But the most critical thing is to, what we call needs assessment, is to get somebody out on the ground, out into all of those affected areas, and to capture the needs of people, and they can be extremely different and varied, and to bring that back and to collate all of that information. It's a massive task. We're sometimes talking tens of thousands of people for needs assessment, and or really if that's in an urban environment, or it could be really difficult to get around all the isolated sites. It could take quite a bit of time. To bring that back to the ECC or EOC to collate all that data and ensure that the right goods, services, support, medicines, all sorts of things are then deployed out to those people if they are having to stay in place. So it's quite a process to follow, and people attempt to do it as swiftly as possible, but obviously the nature of these events is pretty disruptive and quite challenging.
From that, I'm not sure, but would you agree that what I just said is an example of unprepared emergency response for a small rural iwi like Ngāti Koata?
Not necessarily. I think this is where it gets really difficult. I've mentioned the 60-odd agencies before for providing support to affected people. It can take time to understand, especially if telecommunications are down and roads have been disrupted or damaged. It is very difficult to actually collate the data that's necessary and to understand the extent of the damage and to identify exactly every household that has been affected, to actually coordinate the necessary support. It can take time. These are some of the critical gaps, though, that again, I mean, I keep going back to the roadmap and the government inquiry, because we do know that our systems and tools are not fit for purpose. And we are talking, sometimes it's going to take time simply because of the extent of the damage. The area could be, as we've experienced in Gabrielle, half of the North Island to actually cover. That can take days to actually do the reconnaissance flights, or for the information to filter through right from a community level into any kind of organised coordination centre. But equally, it can take time to collate the data and to actually have some sort of meaningful ability to make sense of it, and then task all the necessary agencies to actually deploy resources, which can be anything from psychosocial support as well as goods and services. But the attempt is to do it once and do it well, and to try and be as coordinated as possible. There's a lot of structure and organisation that goes around welfare, right up to chief executive level and central government, in terms of the way the welfare system is organised for all those agencies to come together, wrap around NGOs as well, to try and make sure that those services and support is provided as swiftly as possible.
No, thank you for that answer. That helped a lot. I'm going to jump now to my final area, and this is on Tonga. I'm not sure if you heard our evidence before. If I'm able to take you to paragraph 59.4 of your brief of evidence.
Sorry, was that our evidence?
Yes.
Oh, thank you.
And there you say, specifically, the guidelines state that Māori worldviews, taonga and mātauranga Māori are essential components of risk assessment. Taonga including Māori, customary and freehold land. Wāhi tapu and other cultural values must also be considered when evaluating the consequences of emergency for recovery environments. Now, taonga here includes taonga species, correct?
I would suggest taonga is whatever Māori iwi hapu determine.
Now, Takapōrewa is a coastal isolated island in the Marlborough Sounds. And on this island, there are ecosystems and taonga species, specifically the Hamilton frog and 90% of the tuatara population. Ngāti Kōta are kaitiaki of Takapōrewa and tuatara. I'm not sure if you're aware, but the sex of tuatara hatchlings is determined by the temperature of the soil, and due to higher temperatures, it is causing more males than females to hatch. And it's determined they'll be extinct by 2085. And as kaitiaki of tuatara and Takapōrewa, they are part of the identity of Ngāti Kōta. And you can understand the importance of taonga for Ngāti Kōta.
Yes.
Now, in terms of, you say within paragraph 59.4, risk assessments, taonga is essential component, correct?
Yes.
And there is currently no risk assessments on Ngāti Kōta and their taonga species, is there?
I couldn't say. Our guidance is out to local authorities. And I couldn't say how they've actually done this in Marlborough specifically in this instance.
No, that's okay. I'm just going to ask my last question. Ngāti Kōta and their taonga species are not considered when evaluating the consequences of emergency for recovery environments, are they?
Recovery has, in terms of going to the recovery management guideline, it has 4 and often 5 components of community: built, social, natural, economic, cultural, sometimes gets added, as was done in the Canterbury earthquake recovery, and or it's just across all of the other key components of community: built, social, natural, economic. The natural environment should, we've got a director's guideline, strategic planning for recovery, which is pre-event strategic planning, and it should be carried out by chief executives of local authorities and mayors working with their communities, where they are advised to work with those communities to determine pre-event what do they place value on, and in this instance particularly taonga. And so I think actually these are some of the unique things that communities place value on that should and need to be captured pre-event, so that plans and at least recognition in advance of these emergencies where chaos and all sorts of things get introduced, difficulties around knowing what exactly is valuable needs to be pre-identified. So I think that's actually a good example for the importance of that particular guideline and how it is carried forward.
No, that was perfect. Thank you. That is all my questions. Thank you.
And Mr. Sontia for Loaded Legal.
Tēnā kōrua, ko Jasper Sontia toku ingoa. Can you both hear me okay?
We can, thank you.
Great, thank you for that. So most of my questions have already been asked, but I have just one brief line of questioning that I wanted to take you through. So just looking near the start of your evidence at paragraph 14, you referenced the Māori wardens as commonly being early activated in emergencies. And I represent several claimants in this inquiry today, including Ms. Miriana Peka, who has a claim on behalf of the Turiho Māori wardens, and Mr. Thomas Henry, who has a claim on behalf of the Otahuhu Māori wardens. And so looking at that paragraph 14, I'll just give you a moment if you want to read it. I think it's in the first sort of paragraph of that quote that's pulled out. Have you had a chance to read that?
Yes, thank you.
Thank you. So would you agree that this references the Māori wardens as being commonly only activated in emergencies?
I'd have to take this, I mean, this is a reference from the ministerial review into the Kaikoura Earthquakes Port Hills findings as event specific, but to extrapolate that beyond, I'd say yes. I can't talk with absolute certainty, but I think if it's a finding in the ministerial review, it's probably much wider if you're specifically talking about Māori wardens.
Yes, thank you for that. And so then going further forward to paragraph 192 of your evidence, you referenced the 2017 TAG review. I'll give you a moment to let me know when you've had a chance to read that.
Yes.
And so near the second half of that paragraph, would you agree that it notes that Māori organisations and marae often operate as critical hubs during emergencies?
Yes.
But then further near the end of the paragraph, it says, yet their role is often informal and unrecognised within the Civil Defence Emergency Management Framework.
Yes.
Would you agree? Thank you.
This is, can I just say,
so,
sorry,
yes.
just to qualify, this is very much drawing from the TAG review at its time as well, 2017.
Mm-hmm. Are you aware of whether the Māori wardens are formally recognised within current Civil Defence Emergency Management Act framework?
The current CDM Act, no.
Sorry, is that no, you're not aware of?
No. No, they're not. Can you just
They're not.
ask that question again? Are Māori wardens?
Or maybe being more definitive, are the Māori wardens formally recognised within the current CDEM framework?
The framework's quite broad, but certainly not the CDM Act.
Okay, the Act, yeah, sorry. Yeah. And looking at the upcoming emergency management bill, are you aware of whether there are any plans to formally recognise Māori wardens?
I won't be in a position to answer that right now.
Fair enough. Is NEMA aware of any dedicated Crown funding stream for Māori wardens to participate in emergency preparedness or response?
Not emergency wardens specifically, but as I've referred back to the CDM Resilience Fund, there are opportunities there to support the work if there was any particular project or program Māori wardens wanted to put forward into the contestable fund to support the work they're doing in relation to emergency management. There's the opportunity through that provision, and of course through wider preparedness provisions of that fund as it gets expanded in future.
But so looking specifically at recognising Māori wardens, would it be fair to say that they were identified as critical hubs in 2017 in the TAG review, and 9 years on they remain outside the formal framework and without any dedicated funding?
I'm not sure about the hub reference. You're talking about marae as hubs.
Just to explain that, just me sort of paraphrasing that they were, what was it, what the review found about Māori wardens, that paragraph that we went through.
I would say the findings of the TAG review are still being progressed, to your point, and are at the final stages of that work.
Okay, thank you for that. That's all my questions.
Thank you.
We now have questions from the panel. Mr. Morrison, do you have any questions?
No, Your Honour. Just make a comment. As someone who was a civil defence controller on the Coromandel Thames Valley for 20 years, I understand your work and I appreciate it. Well done, and the development since then. So I just compliment you both on your submissions or evidence and work well done.
Thank you.
Ms. Kapua?
Thank you, Mum. No, thank you. Thank you for the evidence. I have no questions. Thank you.
Kia ora.
Professor David.
Tēnā kōrua. Just a couple of questions. One is from paragraph 39 of your speaking notes today. In New Zealand's history, there have only been 3 national states of emergency. I did a little search on that sentence, and I gather the 3 are Cyclone Gabrielle, which was said to be the 3rd after the Christchurch earthquakes and the COVID-19 pandemic. Now, one of the portai I bring to this tepu as a historian, there are lots of emergency powers bestowed during World War I and World War II, but that particular term, national state of emergency, was declared in 1951 in the time of the waterfront confrontation by the government of the day, with reference to what some call a strike and other people call a lockout, which went on for 151 days. So if your website happens to repeat this statement about only 3 national states of emergency, I urge you to remedy the fact. Secondly, in relation to that, quite what counts as national, because the Christchurch earthquake didn't cover a lot of the country. It had consequences for a lot of the country. So how do you move from the best managed at the local CDM group level as opposed to a national one?
It's a very good question, and actually quite difficult to answer sometimes because of the uniqueness of emergencies, and the pandemic obviously was entirely nationwide and didn't have damaging consequences, for example, unlike the Canterbury earthquakes. It really comes down to the powers that need to be unlocked to support the response. It's actually an important opportunity even to talk about funding. Declarations of emergency have no correlation to funding. They won't unlock funding. They're genuinely there to support either a local group or national controller with the powers they need to protect people, save lives and protect property. Those powers obviously are quite cross-cutting in terms of human rights. You don't want to put them into play unless you genuinely need them. And the sorts of activities they enable are mandatory evacuation. So if you absolutely need to move people out of harm's way, if you need to requisition goods and or resources, and genuinely everything can be requisitioned. So at that national level, for the Christchurch earthquakes, as an example, you're right, it had quite localised, big for that city though, to lose an entire urban environment and thousands of houses, and tens of thousands of people actually impacted in that small location. That really required national and in fact international assistance. We haven't talked about international work at all, but that's another level that gets carried out nationally. The work we do at NEMA with our partners internationally, working through MFAT and others to enable international assistance into and out of New Zealand. We're a very small country with very finite resources and massive hazards. So we have to carry out those sorts of pre-event arrangements. So in that instance, yes, somewhat localised, but a massive scale for that localised community and needing all of the assets nationally and national coordination. So the surging of resources from the whole of the country plus internationally into that small location. Cyclone Gabrielle, different in that it was at least 7 regions and 6 or 7 regions, really far-ranging locations, lots of isolated communities. Again, the complexity of that event and understanding the breadth of damage, the numbers of people affected, the impacts in terms of infrastructure in particular, really needing, again, national level surge support and international assistance again. It's probably not widely known that we did have international assistance for that particular response as well. I will say there's a uniqueness also for events such as Whakaari White Island, or even the mosque attacks for that matter. NEMA gets involved and CEDM gets involved, and same for the pandemic, for any of these crises. And some of them may be somewhat localised, but they can have immediate international implications. So we stand up for every one of those events, right up to the national level and politically and beyond.
Yeah, thank you. I mean, there are quite severe curtailments of ordinary rights and liberties of people under a declared state of emergency. So yes. I mean, that has to be taken into account as well.
Yes.
So secondly, can I just delve a little bit further into the issues that have been raised with you by Mr. Sharp and Mr. Sontia? So it's paragraphs 178 to 183 of your brief of evidence. And it's already been referred to. The desire under focus area 1 to have a quality formal agreements with, amongst others, iwi and Māori, and then the references in paragraph 182 and 183 to the National Iwi Chairs Forum. So they've got a contractual arrangement with you about sharing draft advice and so on. So just to put one possible angle on that is that iwi chairs undoubtedly at some point had a mandate from their people to enter into a treaty settlement. And they are usually the leaders of post-settlement governance entities. There's 80 or 90 of them that turn up usually to those sorts of hui that they have. But they're not necessarily got a mandate to consult, to be the consulting partner with the government on a whole range of issues post-settlement. And there are quite a number of national organisations. You had Mr. Sontia mentioned the Māori Wardens. There's the Māori Women's Welfare League. There's the New Zealand Māori, which has got branches all around the country. There's the New Zealand Māori Council, which has got district councils all around the country. So is there any particular reason specific to emergency management that suggests that you want a contractual arrangement with the National Iwi Chairs Forum, and for the rest you invite them under paragraph 183 to come along to an online hui?
No, is the short answer. I think we have still got a lot to learn as an agency in terms of the opportunities and how we can more meaningfully engage and partner with iwi Māori. The role the NICF has played has been hugely helpful given the timeframes we had to develop that work. I think there's a real opportunity now as we get to the final stages of the bill, or the government gets to the final stages of the bill, and we turn our attention to implementation as to what that looks like. I mentioned also the Director General needing to, and for local government also, but at the national level to engage, take advice, etc., on the development of a national emergency management plan. How we go about that, we are needing to really explore and develop a process that is fit for purpose, fundamentally.
All right. Thank you. That's my questions. Thank you very much for your evidence.
Thank you.
Just before I forget, before moving on to my other questions, do you have an expected date for, or a ballpark date for the bill to have passed through Parliament?
Certainly this year.
Before the election, I presume?
Hoping so.
All right, thank you. I'm just thinking about our report, that's all, and the date we might be reporting. First of all, you mentioned international aid, and certainly some of the future events that New Zealand might face, such as an Alpine fault earthquake, or even a major eruption at Rangitoto or somewhere, we would need international aid. And I'm just wondering, how is the fact that US aid has disappeared, more or less, going to affect our ability to obtain aid from overseas? I'm not sure if you're the right people to ask, but...
I'll give it a go. We have, NEMA actually has a number of memorandums of cooperation with a number of countries, America being one of them, Australia, increasingly in the Pacific. They've got extraordinary capability that's advancing in the Pacific now, and in parts of particularly Asia and Southeast Asia. So we have a number of these MOCs and a number still under development. It's not just unique to New Zealand. International assistance is something that all countries rely upon. Without getting into the detail of just America at this present state, all I'll say is it's a wide boundary. It's not just America that sends these sorts of resources. Japan in particular, even parts of South America. We had a lot of different countries, possibly about a dozen after the Canterbury earthquakes. Urban search and rescue, medical hospitals, all sorts of different assets that we're working through with different countries and different jurisdictions. So there's no one country that we rely upon. Is probably the best way to frame that. And we are developing further and deeper MOCs with more and more countries.
Thank you for that. My next question is just about insurance and the signalled retreat from insurance by various companies, which isn't happening right now, but it looks like it's going to happen. And I'm wondering how that is being taken account of in terms of the roadmap. Sorry, I've forgotten what it's called.
The way I'd frame the roadmap in the 4 Rs is certainly in terms of insurance, critical to retain it for New Zealand. We work in close partnership with the insurance sector. We have an agreement with Insurance Council New Zealand and Natural Hazards Commission to really get after more broadly emergency management and resilience. That was signed only about 12 months ago. We're heavily reliant on insurance in New Zealand, one of the highest levels of insurance cover internationally, and we want to retain that. And yes, they are moving more and more to a risk-based approach, and particularly for climate or hazards, meteorological hazards. NEMA is very focused in terms of the roadmap on strengthening emergency management on, I would suggest, preparedness, response and recovery. In terms of risk management and insurance being a key risk management tool, that is being, I would suggest, progressed more through the adaptation space, through MFE and others. What we want to make sure we are doing to support any work is ensuring that the public are hazard and risk aware, that they're doing what they can to protect their assets. Public education, those sorts of things are some of the things we've got on the work program to work with the insurers. They should be, for example, when they're issuing their premiums, providing good emergency management information alongside them. But most of the work in terms of retention of insurance in New Zealand and ensuring that hazard risk is being addressed through good land use planning or opportunities for retreat in future, etc., is really the work that's happening in the adaptation space.
One of the, nevertheless, the insurance premiums are climbing hugely, and people already under the pump are not really going to be able to afford that. That's soon going to become a nice to have rather than a will have. New Zealand governments in the past have developed the EQC, for example, and that, for all the criticism of it after Christchurch, nevertheless it provided a huge buffer to the response and recovery, and it seems to me that the government is moving away, or this government is moving away from the idea of having a fund of that kind. Am I right in that?
Not to my knowledge. And I can attest to the important place of the Natural Hazards Commission. I think it's we're the envy of the world in many instances.
Okay, that's good to know. It's just that from some of the other Crown witnesses, we've heard that responsibility for recovery and so forth, and yourselves, is at the local government level, and presumably there are pathways for them to receive assistance from the National Hazards Commission.
For local communities?
Yeah.
Yes, absolutely. It's probably misrepresentative, the way that we so tidily capture local, regional, national. For any local, when we say it's managed locally, we mean if the core consequences and damage is local, really that's what is being managed locally. But it's not to say that there isn't regional or particularly national levels of involvement. Roads, state highways, it may be in one locality, but NZTA will still be the entity that will be fixing those state highways. There will still be funding that flows from the national level. NEMA, for example, administers the government's, the Crown's 60-40 policy, which is the Crown pays 60% of the restoration costs for all local government assets, particularly infrastructure and horizontal infrastructure. That doesn't have to be any kind of national level emergency. Even for the smallest, we will pay those costs. There will be support that flows from central government, particularly for welfare and welfare-related costs again. And insurance is absolutely the case. It doesn't matter the scale or size of an emergency, always. There'll be a level of national insurance being paid out.
Mm-hmm. My next question is about the rates cap, but I understand that if there was actually, I'm not sure I understand at all how the rates cap will work in terms of emergency management and preparation, risk assessment and all that sort of thing. Are councils expected to do that work, the pre-event kind of preparation work, from their existing rates?
Yes.
Right. But when the event strikes, there would be other assistance?
Yes. Yeah.
Okay, thank you. Well, my last is really just a comment. I don't know anything about how they predict the weather, but I understand there's going to be a huge El Nino, which will have very severe consequences weather-wise. So I think you're going to be very busy in the not-too-distant future. So I wish you all the best with that. Thank you for your evidence. I'll just hand you back to your counsel to ask any questions by way of re-examination.
No further re-examination, Your Honour, but just to thank the witnesses for your time and for your evidence in assisting the inquiry.
Thank you. Kia ora.
So thank you again.
Thank you. We looked forward to seeing your findings as well.
Well, actually, we're at afternoon tea time, so we will take the break, and hopefully the Honourable James Shaw will be online at 3:30. Welcome back, everybody. I hope... Oh, Mr Sharp is on the line. And Mr Sharp, it's 3:30. We're just wondering what the situation is in respect of Mr Shaw's appearance.
Yes, ma'am. As advised the registrar, Mr Shaw said he had a appointment which he expected would be completed by 3:30, but he couldn't be completely sure, so he was going to be communicating with me once he has finished the meeting. So I haven't heard back from him yet.
All right. If you can keep in contact with the registrar, we'll take a further break.
Yes. Before we do, Mark, just while we're here, I understand that there has been leave granted to some lawyers to ask questions of Mr Shaw. I wasn't here, so when that occurred. I've got some documents from Sykes & Co. about they want to put to Mr Shaw. I've sent those to him and he's acknowledged receiving them. So I think there was also Phoenix Law.
Yes, that's right. Who wished to ask some questions. Ms Boatwright, did you want to expand on what kind of questions you wanted to ask?
Tēnā koe te kaiwhakaua. Tēnā koe, Mr Sharp. Sorry, aroha mai. Yes, so the questions that we're going to be asking Mr Shaw this afternoon is all in relation to the kōrero that he's provided within his brief of evidence. We don't wish to stray outside of that brief of evidence, hence why no further supporting documents have been filed by counsel in relation to that cross-examination.
Yes, ma'am. I just asked, of course, the tribunal's time and Mr Shaw's time is limited, so, and I presume there'll be a number of other counsel who want to ask some questions in writing. So I just asked that that there be some sort of limit on the degree that questions put to him today be sort of put in place or police, so we're not straying too far from the times.
Yes, the time that Phoenix Law have indicated is 15 minutes, and Sykes & Co, and I believe it's Mr Fletcher who will be asking the questions, have indicated 10 minutes. I've checked with the panel and we do have some questions, but we do anticipate being able to complete any questioning so that within an hour. Was that the time frame that you understood Mr Shaw would be available for?
Yes, it was.
Yes, all right. So yes, if you can keep us apprised and...
yes, I will. I'll get back very shortly to the registrar.
All right, thank you. So we'll take a further break in the meantime. Oh, just for those of you who are here, 4 o'clock was the time, so I'm anticipating that it won't be later than that Mr Shaw arrives.
Yes, that's our understanding, and also we do have questions that we'll formulate, but they will be in writing, and our other witness is not ready for today, so once he's finished, we are finished for the day.
I won't say yippee.
Ma'am, if I could briefly address you.
Yes.
I am covering for Mr Vincent, who's tapped me in, and I have 3 questions from him, so I'm not sure if he gave you a 10-minute estimate, but I'm not taking 10 minutes. If he wants to take questions in writing, I'll seek leave for him, but it won't take me that long.
That's fine. Thank you.
Aroha mai, te kaiwhakaua, just one more thing. During the afternoon adjournment, Mr Fletcher and I had a kōrero. We're proposing that Phoenix takes the first amount of cross-examination, followed by Sykes & Co.
All right. Thank you, Ms Boatwright. Welcome, Mr. Shaw. I hope you can hear me. Yes, you're on mute at the moment. Okay, good, thank you.
I can hear you perfectly.
Good, thank you. Mr. Sharp, your counsel will have told you that we do have some questions for you from two of the claimant counsel, and so we will begin with that and then move to questions from the tribunal. And we have read your brief of evidence, and so that has been taken as read. So that's all fine with you? Good. Okay, I'll hand over to Ms. Boatwright, who is our first questioner.
Tēnā koe, Mr. Shaw. Just confirming you can hear me okay? Ka pai. Ko Ms. Boatwright tōku ingoa. I represent several claimants within this inquiry, predominantly focused in Te Tai Tokiro, but all over Te Ika Māori. Mr. Shaw, I won't take you to your brief of evidence, but just to let you know that my pātai will be focused on what you've already provided. Now, you explained that during your time as the Minister for Climate Change, you regularly engaged with Māori, including but not limited to iwi leaders forums. Is that right?
Yes, that's correct.
Mm-hmm. And those forums were an important way of hearing Māori perspectives at a national level, weren't they?
Yes, and at local level. So there are obviously, different nuances in different parts of the country. So, talking to kind of individual iwi was an important part of it as well for me.
Mm-hmm. And would it be a fair assumption to make that the engagements that you had with Māori and iwi were primarily advisory in nature, rather than Māori themselves having decision-making authority within those processes of engagement during development of policy?
Yes.
Mm-hmm. And so ultimately the end final decisions about policy, which included the emissions budgets and the reduction plans, remained with Cabinet, correct?
Yes.
And just so we're clear, engagement at that national level and also the localised level doesn't necessarily mean that every affected iwi or hapu were directly engaged in a tailored way, were they?
No, that would be correct.
Okay. Now, for example, throughout this inquiry, the tribunal has heard evidence from Waitangi Pōtiki and Ms. Roana Bennett of Ngāti Whakauē ki Makatū. For the record, that is that brief of evidence with the appellation A32, where they say that they do not ever recall being contacted to engage specifically as the Ngāti Whakauē iwi, and instead they only had access to general public consultation processes with the Crown. Would you accept that experiences like that could occur even within a system that is trying to engage with Māori and iwi at all levels?
Yes, I would. There were this would be a line of inquiry, that you'd want to chase with Ministry for the Environment, but they had, there were kind of numerous examples where, they would kind of send an email to iwi and other Māori organisations, and then kind of engage more directly with those that responded, which was usually a pretty small minority, and that largely came down to the resourcing that those individual iwi had to be able to respond to requests from the Crown for engagement. And of course, we weren't the only, Crown kind of grouping that was trying to engage with Māori. You had kind of things going all over the place. So of course, people needed to prioritise about what they responded to.
Tēnā koe. Now, you've described the, I guess that you could say, your government's intention to reflect treaty principles and Māori interests in climate policy. And now, confirming that this was clearly a priority during your time as Minister for Climate Change? Sorry.
Yes, it was. Yeah.
And now, would you agree that the processes in relation to policy development, which largely occurred through central government processes, can sometimes be physically and culturally distant from the day-to-day realities of communities experiencing the impacts of climate change?
Yes, my hesitation is that I obviously don't have lived experience, but that was certainly reported back to me many times by Māori communities throughout the country.
Mm-hmm. And now furthermore, we've also heard from Ngāti Whakauweki Makatū that they felt that there was a sense of disconnect where the decision makers in Te Whanganui-a-Tara are removed from the whenua and do not share the same values as iwi Māori. Does that statement reflect a challenge that you had observed, that translating national policy into locally meaningful engagement was difficult?
Yes, so maybe let me answer that slightly obliquely. As I said in my submission, I don't claim to be an expert on te tiriti matters, so I relied on advice for the approach that we would take, and that advice came from within the government in the form of Ministry for the Environment, Te Ara Whiti, the Climate Change Commission, and so on. And so in trying to shape our kind of climate policy response within government, I was kind of relying on Crown agencies. So I then, in the kind of, when I was engaging externally, that was kind of a way of sort of testing or validating what I was hearing kind of from various Crown agencies. But ultimately, the approach that we took around establishing, and I still hate the name of this, and it was only ever interim, but the Māori Climate Platform was on the advice of a Crown agency, which was the Climate Change Commission. Mm-hmm. And so I thought it was important for us to follow that advice. And the sense that I got both from those agencies and from the feedback that I was hearing from iwi and Māori groups around the country was that the kind of the best approach would be a kind of independent by Māori for Māori approach, which is kind of what led to the decision to try and set up an independent platform, which ultimately didn't happen with the change of government in 2023.
Mm-hmm. I just want to move on to the intent and the limitations of the Māori Climate Platform. Now, is it correct to say that the initiative was designed to move beyond consultation with Māori, but toward a more enduring partnership structure between the Crown and Māori?
Yes, and this is the point that I tried to make through my written evidence, was that the intention was that there would be an independent Māori-led climate initiative. The Crown would fund that, but we were kind of very cautious about being involved in how it got designed, because that would just repeat the pattern of the Crown kind of dictating the terms of engagement. And so, that's why there was a kind of multi-stage approach where, because it sort of had to start with a kind of a Crown approach. There was a sort of a design phase, which then kind of led on to, or was supposed to lead on to, the establishment of an independent body, but didn't.
Mm-hmm. And so while the intent and the design of the Māori Climate Platform was in place, it's clear that the platform did not have the opportunity to be fully operational and be stood up to deliver outcomes related to climate change on the ground with Māori.
That's correct. I mean, we essentially ran out of runway because that setup stage was happening in an election year during the course of 2023.
Mm-hmm. And so in that context, where we have heard evidence from communities that are heavily affected by climate change, like, for example, Ngāti Whakaue, that they were not receiving direct engagement or support, would it then be fair to say that mechanisms like the climate platform had not reached or benefited those communities in practice, despite, given that it was not initiated in its full form?
That's correct. And of course, my direct involvement ended at the end of 2023, so I can't speak to much beyond that.
Of course. And I just want to move on to, lastly, to the resourcing and ability to act. You would agree that meaningful Māori participation in climate change response requires not just engagement, but resourcing and the support to act. Is that correct?
Yes.
And that would include the ability for communities and iwi Māori to implement their own adaptation plans, reduce emissions and build resilience?
Yes, that would be ideal.
And where communities are developing their own plans, such as the Makitu Climate Adaptation Plan, but are not adequately supported by central or local government, that would suggest a gap in policy intent and implementation, correct?
I would think so, yes.
Mm-hmm. And just lastly, you acknowledge in your concluding remarks of your evidence that Māori are often more vulnerable to the impacts of climate change. Now, that vulnerability can further relate to factors such as geographical location, infrastructure, and socio-economic conditions, right?
That's correct.
Mm-hmm. And many Māori communities, particularly our rural and coastal hapori, face compounding challenges in responding to climate change that are different to what your urbanised Māori would face. Is that correct?
Yes, and they're kind of the same challenges that pretty much anybody in the country faces. Those challenges are different whether you're rural or urban, but Māori, the evidence and the advice that I received from Crown agencies was that Māori were disproportionately affected compared to the general population in both urban and rural settings, but particularly rural because the resource base and the extent to which assets, economic assets as well as cultural assets are kind of geographically exposed.
And so taking all of that together, the likes of Māori being more vulnerable to climate risks, the engagement process is really reaching communities directly, structural initiatives taking time to have effect, and the resourcing really reaching the community level. Would you agree that those combined factors can result in Māori communities not experiencing the intended benefits that are set out in climate change policy?
I would agree with that, but of course I can only speak to climate change policy for the period of time that I was in government. The intended policy may well be different now from what it was then.
Of course. And during your time, just finally, just during your time as the Minister for Climate Change, would you accept that it highlights the importance of continuing to strengthen engagement, partnership and resourcing at all levels, which would be consistent with Te Tiriti and Māori?
I would, and as I said, I'm reluctant to provide an opinion about what I think would be consistent with Te Tiriti on the basis that I'm not an expert, but certainly the advice I was getting from Crown entities was that. Yeah.
Tēnā koe, Mr. Shaw, and nā mihi mō tō mahi I te kaupapa. Tēnā koe te kaiwhakaua.
Tēnā koe.
Thank you. The next questions are from Mr. Fletcher of Sykes & Co.
Tēnā koe, Mr. Shaw. Can you hear me okay?
Tēnā koe, yes.
Fantastic. I'm asking some questions very briefly of you on behalf of my colleagues, and they've filed some evidence from Jane Kelsey, who you probably know from general knowledge, has got quite a lot to say about ISDS clauses. Yes. And so I will just quote the article that Mr. Sharp told us he'd sent you, where you were interviewed by The Guardian, and I really just wanted to make sure you had that so we were slightly familiarised with questioning under tight timeframes. So sure. Just quoting from what you said to The Guardian, discussing the 2018 oil and gas ban, you said, when we implemented the ban on offshore oil and gas exploration, we had to construct that incredibly carefully in order to avoid the risk of litigation, and that meant you had to leave the existing permits in place. And you also said that you talked about the implications of ISDS around the cabinet table, with particularly MFAT pushing back on environmental policies because of the risk of the Crown ending up in international litigation. I wanted just to ask you a really broad question. How much do you feel ISDS clauses constrain greater environmental regulation by the government?
Well, that is a broad question, and it gets. It'll be different in different domains, and of course, you know, those clauses cover different agreements, and include some areas and exclude others. So, you know, I will constrain my response to the ones that I had the most direct involvement with. And of course, you know, I was an Associate Minister of the Environment for Biodiversity in my second term. But for the two terms, I was Climate Change Minister. And whilst there was obviously a group of environmental ministers, David Parker was the Minister for the Environment for that sort of period. And so he would be a better person to ask about the broader kind of implications. But the example of the oil and gas exploration permits was, I think, illustrative of the wider point, which was that when a block offer was made, and you know, companies responded to that, and if they won the block offer, then that created a property right, and so that was the trigger point for which, if that was then reversed out, they could then claim, you know, compensation or damages of some description. So I think the evidence that we got the policy right legally was that there were no claims, because when you're opening up, if you don't make a block offer, you're not creating any property rights, right? So there's nothing to claim against. Now there will be people in the industry who will say, well, you know, but that killed investment in existing fields. But there was no change to anybody's property right at any point. So those fields where exploration was continuing, if any of them ever came to fruition, they would still have the full right to then exploit those fields. And so, because we think it's important to act within the law and act within those trade agreements, the policy decision that we made was to be consistent with those. So I think you then could apply that to any number of kind of similar situations. The advice that we got from officials was always very conservative, and that's probably appropriate. But my sense of it, and I'm choosing my words carefully, my sense of it was that there was generally more latitude than we were advised if we kind of really wanted to push something. But obviously, if you did really want to push the boundaries, that was going to increase the risk. And given the scale of kind of economic interests involved, we could easily find ourselves in court, and then what would otherwise be a fairly significant policy win would turn into a loss. So we didn't want to risk that.
I'm conscious both of the tribunal's time and yours, but I did want to supplement that when we talk about conservative policy advice. You're more familiar with this area than me. I've been upskilling on it today. But speaking as a lawyer, the threat of litigation, and particularly the cost of litigation, is often by itself sufficient to deter a lot of people from wanting to take risky policy choices, even if you're comfortable within that conservative policy paradigm that you're probably right.
Yes.
Was that your experience too? It's probably partly why officials were quite conservative. I imagine these cases in America or in foreign arbitration courts are very expensive to defend.
Your Honour, I'm very sorry to interrupt you, Minister Shaw, and the line of questioning. My name is Jeremy Preble. I'm acting for the Crown in these proceedings. I would just raise one point, which is obviously under the Cabinet Manual. Ministers, and I would suggest former ministers still needing to consider whether or not advice they receive from officials is legally privileged before inadvertently waiving it. So I just make that note, and it may not be the case that you feel that is relevant to you, Minister Shaw, but I think it is appropriate just to raise that for your consideration before you embark on answering these questions. Thank you.
Can I respond to that?
You've probably just illustrated the point, actually, Jeremy.
Yeah. Can I just briefly respond? To be clear, I'm not asking to intrude into specific privileged advice about a specific claim, hypothetical or otherwise. I don't accept that the prospect of abstract claims and whether they're costly is something that attracts legal privilege, and I think my friend would need a little bit more explanation for that. And I really wanted to respond because I wouldn't want the witness to feel unable to answer because of what I think is perhaps a slightly too enthusiastic objection from my friends. I was quite careful how I asked that question.
Yeah, I mean, it's on the public record what the cost of litigation is in New Zealand around the world. There's plenty of research that's been done into that. So, anybody is going to be cautious about sort of engaging in that. If I was to reverse out, kind of frame it in different kind of ways, one of the things I always worked for in my kind of overall policy framework, particularly when it came to the Zero Carbon Act, was that actually New Zealanders should always have recourse to the courts, and that the Crown should take it on the chin. The advice that I received was that, and I think this is also a matter for the public record because it's been published in other areas, the advice that I received was that we should limit the law to limit the Crown's potential liability. My view was that the best way for the Crown to avoid ending up in court was to follow the law. And that actually you should construct your laws as you want them to be constructed, and then your best risk mitigation is to stick within it. and you know, so I'm kind of quite a big believer in the legal process here, but it does mean you have to uphold both sides of it as well.
Just one final question, and I'm conscious that you've already said to my friend that you understandably don't feel like you're an expert on te tiriti, but I just wanted to ask you specifically for the benefit of the tribunal whether you feel these kinds of clauses constrain, I'm going to frame it this way for you, the Crown's ability from being a better treaty partner or complying more fully with the treaty.
Those clauses, I believe, do constrain the Crown's ability to pass environmental regulations that would meet the scale of the climate crisis and other environmental challenges that we face. And therefore, if you also accept that Māori are disproportionately exposed to risks from climate change, and you also believe that, or accept the proposition that the Crown has an obligation under te tiriti in order to ensure that that does not happen, then it would follow that those clauses do make it more challenging for the Crown to meet its treaty obligations, as you've suggested.
Thank you very much for your time. Ngā mihi.
Mr. Shaw, we now have questions from the tribunal, and our first questions come from Matua Kevin Prime.
Kevin, you're on mute, or I can't hear you.
Aloha mai. I'm Kevin Prime from Ngāti Hine in Northland and a member of the Climate Change Panel. My question is pertaining to the last sentence in paragraph 33 of your statement of your paper, where you say New Zealand is currently one of the worst emitters in the world and with one of the least ambitious targets in the OECD. To me, that's quite a bold statement, and my question is, where's the evidence to back that up?
So the first half of that sentence, where I say, however, on most indicators, such as consumption emissions per capita, production emissions per capita, emissions per unit of GDP, etc., New Zealand is currently one of the worst emitters in the world, with one of the least ambitious targets in the OECD. That, I think, is fairly well established in evidence. Now I'm going to struggle to reference the precise cabinet paper, but we summarised this when I took the paper to amend the nationally determined contribution in, I think, 2022, where we did a comparison of where we sat against a basket of other countries in terms of what our nationally determined contribution was, and we, I think the very first part of that paragraph where it says it's up to each country to determine what its fair share is, there are a number of measures of fair share, and it includes some of those things like, consumption emissions, emissions per capita, emissions per unit of GDP, and so on. And on those measures, when we modified the nationally determined contribution, according to those measures, we just scraped in to the kind of bare minimum of what a 1.5 compliant target would look like on a sort of a fair share basis. And so that's kind of what I mean by that paragraph. Now, that cabinet paper was a summary, but if you went to the references and to the appendices and the work that was done behind that, then there would be a series of kind of pieces of evidence about where we sit on kind of each of those measures.
Thank you very much.
And sorry, I'll just supplementary. So also there's an international organisation called Climate Tracker that uses a number of these measures to sort of work out where countries are sitting. And we're generally a poor performer on the Climate Tracker. Now you can agree or disagree with Climate Tracker on which indices, but on most of them we don't stack up terribly well compared to other OECD countries.
I'll check it out later this evening. Thank you very much. I've no other questions. Thank you.
Mr. Morrison?
Kia ora, Mr. Shaw. Good to
Kia ora.
see you again. And thank you for your evidence. I note that it's almost 12 months old, but however, and things have moved on a little bit since then. However, I do appreciate your commitment to attending today. I understand you're in Singapore at the moment, and I thank you for making the effort. You obviously would be a busy person to appear today. I could sit down and have a talk to you for 2 hours, but I don't have that. I don't have that pleasure. So
one day,
one day over a cup of tea. But in all seriousness, thank you for your submission. Appreciate it, and appreciate you attending and giving us the opportunity to speak to you today. Thank you most sincerely. Go well.
you're welcome. It's a privilege.
Can I just endorse what Mr. Morrison has just said about you making yourself available when you must be a very busy person. I just wondered if you did have any comments about I suppose it's unfair to ask you this really because obviously you put such a huge amount of effort into the Climate Change Response Act and the various elements of that. But I did wonder if you had any comments about the direction of travel that we're now on in terms of whether you think it will assist us to reduce our emissions. I think I'm particularly referring to the change to the methane emissions reduction target as one particular example of where New Zealand, with the change in our ambition is shown.
Well, it's not going to surprise you that I have opinions. So let me, if you don't mind, we've got a few comments here. So first of all, seeing as you asked, I'll specifically about the methane target, I'll start with that. I mean, there's a lot to say about it, but the key factor, I think, is one that's actually been aired in the news recently, which is that the target that the country has is an economy-wide target for emissions reductions and removals. And if in separating out the methane target from long-lived gases, you're essentially making a call on and having every sector of the economy except agriculture in the ETS. You're making a judgment call about the relative effort that the kind of methane, primarily, I mean, there is a small amount of methane from waste which is inside the ETS, but the vast majority of it sits in the agricultural sector and is outside the ETS, and outside any pricing system. That you're making a judgment about the relative effort that agriculture needs to make versus other sectors of the economy. And in lowering the methane target, what you're doing is increasing the amount of effort that the rest of the economy has to make to compensate in order to hit the economy-wide target. And in my view, that's unbalanced by the change and unfair, given that every other sector of the economy, has an economic impost in the form of the emissions trading scheme, and agriculture doesn't. So to lower the effort without, and sort of increase the effort and the cost on every other part of the economy, I think is unbalanced. Now, there will be people, of course, who say, that the very basis of decision making around this is incorrect on, pick your methane measure and so on and so forth. All of that, I think we can leave to one side for the purposes of this. To the extent that then, from this inquiry's perspective, imposes costs on Māori communities, and that sort of relevance to the treaty, I think, there's a sort of, there is a connection there that is worth exploring. Now, moving on from that, I think my opinion was that the climate policy response that we had was generally inadequate to the task. I thought that it was greater than the response from the government that preceded us, and I think it was greater than the response of the government that followed us, but I don't think that we were in any way meeting the kind of scale of the challenge in the time that we had available. And so, kind of everything that I have to say is sort of framed within that even the enormous effort, what I've considered the enormous efforts that we put in, I don't think were kind of up to scratch, including the policy response that specifically related to iwi and Māori communities. The point that I made earlier about the Māori Climate Platform was that the advice that I received from Crown agencies, the Climate Change Commission and so on, and from Māori communities themselves, was that a stronger response would involve an independent Māori-led, by Māori, for Māori entity, resourced in some way through the Crown. And at that time, the resourcing was paid for by polluters because we had revenue coming in from the emissions trading scheme that we were recycling into a variety of initiatives. And that seems fairly consistent with sort of, principles that polluters should pay, and that the proceeds that are raised from putting a price on pollution should be recycled into efforts to both mitigate the impact of the pollution itself and improve the sort of response to the effects from that pollution. So I do think that the current response doesn't meet the advice that we received from Crown agencies during my time in government, when we were forming the first emissions reduction plan. My understanding is that the independent Māori Climate Platform was not established, and that whilst there is a fund that is administered by the Ministry for the Environment, or the about to be former Ministry for the Environment, that is not an independent by Māori for Māori response, although there are Māori organisations that are consulted on the use of that fund. And then the next kind of adjunct would be, is the scale of that fund anything close to the scale of the challenge that Māori communities are facing? And you only need to look at the various states of emergency from extreme weather events in the first quarter of this calendar year to suggest that actually the scale of the response is still inadequate. So the next thing that I just wanted to sort of touch on is, given your question, it is kind of sort of more of a macroeconomic question, which I just wanted to kind of return to that theme about the extent to which Māori are disproportionately affected by the effects of climate change, which was advice that we received from Crown agencies and also, backed up in academic research and sort of experience on the ground. I often hear that the cost of, trying to transition the economy to a low emissions economy is greater than the cost of not trying to do that. And I think that you've got some evidence from Kieran Murray of Sapere that is essentially to that basis. I dispute that for a couple of reasons. First of all, electricity is cheaper than fossil fuels, and so transitioning to a fossil fuel-free economy actually brings a net economic improvement across the whole economy, at the household level, at the farm level, at the marae level, at the business level, and in kind of various scales of community, from local right through to the impact on your national accounts. So there's a kind of, definite benefit that economic benefit that you get from modernising your economy and moving it off fossil fuels and towards one that uses renewable energy primarily. Now, there are also opportunities if you're a kind of land-owning entity, Māori trust, etc., where carbon markets and nature markets and so on actually bring additional revenue into those communities, and you can, with good reason, argue many aspects of the New Zealand emissions trading scheme, but it has significantly increased revenues to landowners, including to iwi and Māori landowners, above what they would otherwise be able to get from the use of that land. So the transition comes with economic opportunities. It's not just a pure cost basis. And the vast majority of the policies that we tried to put in place were actually ones where we were trying to either reduce costs or increase revenues to various communities through the transition. Right, it wasn't just about imposing cost, which is why all of those ETS revenues got recycled into transition measures and so on. And anybody can argue the kind of benefits or not of each of those individual policies, but that was the sort of the broad thrust. The other point I think that Mr. Murray made in his submission is that New Zealand is too small, emissions are too small to make an impact on climate change, and therefore anything that we do won't fix it, and therefore there is no cost difference to Māori between doing something or not doing something. Now, he does say that there is a moral requirement for us to contribute, but not an economic one, and I disagree with that. For the practical reason that this is it is, as he correctly points out, a global challenge, one that applies to every country, and there are approximately 90 countries in the world that have an emissions profile that adds up to 1% or less of the global total. But if you add those 90 countries, which New Zealand is in that class, right? So we are one of about 90 countries in that class. If you add those countries together, that adds up to about 30% of the global total of emissions. And that is a larger number than the United States, than the European Union, than China, or than India, or Russia, or kind of any of the single largest countries. And so if you say, well, New Zealand is too small to make a difference, and therefore we shouldn't, what you're then saying is to those other 90 countries, the other 89 countries, you also don't need to do anything because individually you're too small to make a difference. And what you're therefore saying is that actually 30% of the global total doesn't need to do anything because the individual constituent parts of that 30% are too small to make a difference. So now what you're saying is that the remaining 70% has to do all of the work. But then if you said, okay, well, New Zealand has a population of about 5.5 million people, that's roughly half the size of Los Angeles County. Is that what you're saying is, well, actually Los Angeles is too small to solve climate change, so it doesn't need to do anything. By which you're then saying Chicago doesn't need to do anything, New York doesn't need to do anything, Houston doesn't need to do anything, and therefore the United States doesn't need to do anything. But at a national level, it is one of the largest single emitters. So when he says there's a moral obligation, but not an economic obligation, I would actually say, no, there is a very practical obligation, which is that any constituent component of the global economy has to play its part, has to do this. That's a very practical reason, because you can divide this up according to countries or according to federal states or according to cities and so on. But we are, frankly, all on the hook for this. And smaller countries than ours have harder targets than ours, have set themselves harder targets than ours, than us to meet. But I think it's an economic fallacy to say that the transition is a net economic loss rather than a net economic gain, because all we are talking about really is kind of modernising the economy and moving towards, amongst other things, moving towards the cheapest form of energy ever created by the human race, which is solar plus battery. So I know that that's a very high-level response to your question, but it was a broad question. But if you then kind of draw the implications down in terms of the nature of the inquiry that you're looking at, I would argue that there is a direct line there between what Māori communities experience on the ground, the costs and opportunities that they have in front of them, the challenges that they face, the Crown's obligations, not just to Māori, but as our kind of organising principle as part of the kind of global coordination around this challenge.
Thank you for those comments, Mr. Shaw, and I might add the comment that it does seem to me that we're pretty good at saying that costs of borrowing, for instance, need to be repaid by the current generation rather than leaving it to our grandchildren, but we don't seem to take quite the same view that we're leaving costs and problems to our grandchildren in relation to climate change. That was that was my.
I have a thesis there about the discount rate that Treasury applies to transitions, but that's a whole other that's a whole other rant.
Well, let's not call it that. I did want to ask you that broad question, but that was my final question. You'll be aware that the Crown will have questions for you in writing, and I think some of the other claimant counsel who didn't ask you questions today may also have some questions in writing. I'll just hand you back to your counsel in case he has any questions by way of re-examination.
No questions, ma'am.
All right. Well, let me thank you again, Mr. Shaw, for making your time available to us, especially as you're in Singapore and you're a different time period as well. So may I wish you the best for your work over there.
Thank you, and I look forward to reading your determination.
That is our last witness for today. I'll just check whether there are any matters that need to be raised about the timetable or the witnesses for tomorrow. I think we're all pretty clear now that that's all been settled.
I think so, Your Honour. I think we're just following the same timetable, but with Mr. Stocks in place of William John Martin.
All right. So we'll see you all at 8:30 tomorrow morning, and I'll ask our kaumātua to close for us.
Kei nui tātou. E pae tō mātou matanu I te rangi. Ko mātou hoki o eni au punga e tū tunu nei mo I tū aroro. E whakamui miti tunu nei tū ingoa. Punga manaki tanga I ho mai koe ki runga e mātei. I rui e mai koe ki runga e mātei. Tēnei rā mai te tīmatanga I te ata nei tainu ki tēnei hauranga kamutunga. Mana ki tēnā koe e mātou we he atkini o mātou kāinga, we he atkini te oki oki. Kia hoki kaha mai ki tēnā hoa pōpō. Te ino ki tēnei kia koe pā maune whakamana mai. I runga ni te ngua tau tama te kai whakora koe I Karachi. Āmene. Kia ora tātou.